in New York, but just really excited about what we're able to celebrate today and that which today brings. So I can't believe it's the 75th anniversary of the Oklahoma Law Review. And as we are gathering to talk about name, image, and likeness in college athletics, it's interesting how much and how far things have come at the College of Law and with this particular intersection between law and culture and society and colleges and everything that we're doing. I mean, so much has happened over the past 2 years. It feels like it's just zoomed forward in appreciable ways. And I think, though, when I think about the change and progress and alterations and ways that we can respond there too, and when I think about how excited I was to be invited to welcome everyone to our campus, to our buildings here at Sam Noble, the College of Law across the street and so forth, I'm just reminded. I'm reminded of a couple things, and I'm mostly reminded of how critical our students' work is. Our students, our faculty, our staff, our entire community, all of you, the work that is done together on something like this, where we're not simply focusing on one particular tangible outcome, or we're not focusing on a building or the beauty of a particular day, but rather the relationships between theory and doctrine and practice, between different departments across campus, between and among students and alumni and those who are speaking, our guests, those who are here today to be discussing all of this. That's really where such a cliche, I suppose, but that's kind of really where the magic happens. Our students have worked incredibly hard on this day, on this weekend. But again, it's in those interstitial elements and qualities, those relationships between and among all of these different, sometimes seemingly disparate arenas. But when we find that common ground and we find ways to move forward in inquiry as today brings, I just think that's really a very special thing. And I think it's something that is emblematic of that which we do at the University of Oklahoma College of Law. I was at an event just last night, and this is 75th anniversary of the Oklahoma Law Review. Last night, we celebrated the 51 wonderful years of the clinic, of the College of Law clinic. And the clinic director, Professor Amy Pepper, made a comment that was somewhat similar. And I think what she said was evocative, and I also think that it applies well to that which we do today. And it's simply about relationships. Talking, discussing, listening, learning, sharing, having those opportunities, that provides incalculable benefits to all of us. So there is just so much gratitude for everyone putting this conference together, and we're really excited to welcome you to the College of Law. One last little quick point of privilege. Again, we think about the physical outcome. This is the Oklahoma Law Review edition or issue that just came out somewhat recently. I know today is about a different symposium, but we remember in it one of our colleagues who passed last year. His name's John Foreman. And again, when I think about relationships and I think about how yesterday informs today and how what we do today obviously affects tomorrow, we think about John Foreman, and maybe we all kind of celebrate that which he brought to our community collectively as well. So thank you for this morning. Thank you for inviting me to say a few words, and I'm excited to get started.
All right. Thank you, Dean Guzman, and good morning, everyone. I know we had some people come in too. Go, get seats. And so I would just also like to welcome you all to the Oklahoma Law Review's annual symposium. Our topic today we're going to discuss is name, image, and likeness in college athletics. None of you are here to hear me talk. I'm not here to hear me talk, so I'm going to be very brief and introduce our keynote speaker in just a moment. One quick housekeeping matter. If you would like to receive CLE for today's presentations, there is a sign-in at the welcome table out in the lobby. If you didn't do so when you came in, there's a break after the first panel. So go sign in and we will make sure you are all set up for that. Also, before we begin, I want to just do some brief thank yous. One, to the College of Law and their administration, including Dean Guzman, for their support in putting together the wonderful event. Also our staff who work behind the scenes tirelessly to make this look seamless. in particular Carol Booth, Shannon Overstreet, our IT staff who are up there and make everything run smoothly. And those I didn't mention, I appreciate all of you. I also wanted to quickly express appreciation to Dr. Martin Lopez for sponsoring our symposium breakfast this morning. It's generous contributions from friends and alumni of the College of Law that allow us to bring in speakers and host events for not only the law school, but the community. And so it's very much appreciated. And I also want to thank the OLR students, especially Miss Ann Cape, who was running point on this event today. They've worked on the planning, the hosting. They're here, so helping out today and last night. I really appreciate it. Their work is not done after today as well, because they will do compiling and editing and putting, the print edition together for the symposium. So thank you for your work thus far. Thank you for your continued work. And finally, I would like to thank my colleague, Professor Kit Johnson, who helped co-organize today's symposium, as well as is presenting on a panel. So she's doing double duty, and truly, truly appreciate all her work today. So the tiny 1 minute of background, the idea for this symposium today grew out of an event the College of Law actually hosted last spring, the inaugural Wilkinson Family Speaker Series, which was titled Avoiding Fraud in the Era of NIL and Student Athletes. And that program focused primarily on financial fraud, asset mismanagement, investor education. But what became clear to me during the preparation of that event was that the introduction of NIL into college athletics actually raised countless issues that span across many different legal fields, from antitrust to IP and employment to immigration and contract law and business law, and you name it, it comes up in this area. And so, described in the media and some academic accounts as kind of the wild, wild west right now. NIL is a dynamic and constantly evolving area with little guidance right now for institutions of higher education, conferences, athletes, lawyers, agents, and many more that are involved in college athletics. So I think today's Law Review Symposium provides an ideal platform for bringing together thought leaders in this space, for sharing ideas, engaging in critical discussion, and hopefully coming up with some ideas about how to navigate the NIL landscape. And so I think, we're very fortunate today to have with us some of those leading voices from around the country to discuss just a tiny sliver of all the many questions and problems that are arising today for college athletes and colleges and universities. So our hope is that today's programming is both informative and thought-provoking. It leads to ongoing discussion and further examination in this area. And so with that said, I want to introduce our keynote speaker who's going to be kicking off our program today. Professor Mark Edelman is a professor of law at Baruch College, the City University of New York. He's a nationally recognized expert in sports law, antitrust law, intellectual property, gaming, fantasy sports law. In addition to his full-time role as a law professor, Professor Edelman serves as the faculty athletics representative for Baruch College and as the founder of Edelman Law, where he provides legal consulting and expert witness services to businesses in the commercial sports, entertainment, and online gaming industries. He's a highly respected scholar whose research is frequently cited. He's been interviewed on sports law issues by CNN, CNBC, and he's in the Financial Times, New York Times, Wall Street Journal, Washington Post. I could go on with all his accolades. He is one of the go-to scholars in this space. So I'm excited to hear what he has to say. And so if you will please join me in welcoming Professor Mark Edelman.
Before we get started, just by a show of hands, how many people here are on a law journal? It doesn't have to be Law Review, any law journal. 20 years ago, literally 20 years ago, I was in about the exact same space as all of you. I was a 2L at a large public state university with a very good football team that was not having the best of seasons. And like any 2L, I was told that one of my tasks was to write a student note. I had one elective first year of law school. It was sports law. It was my favorite class. I was taking antitrust, and I decided to write my note. It was entitled Reevaluating Amateurism Standards in Men's College Basketball. The thrust of my note was when the 1,200 NCAA member colleges came together. And as part of their principle of amateurism, all agreed with each other that not only would they prevent their own athletes from endorsing products, but they would prevent athletes at any other school from endorsing products. In my view, that was a violation of Section 1 of the Sherman Antitrust Act. And I argued that the NCAA's restraints on college athlete endorsement deals needed to be lifted. Not only did I make that argument from an antitrust perspective, in terms of the restraints on free markets for athletes themselves and potential sponsorship opportunities, I also discussed the adverse effects that the current NCAA rules had on low-income college athletes, disproportionately African-American college athletes, and the role that some of these financial restraints played in influencing these young athletes to leave school, when some of them may have stayed if they had the opportunity to both get an education and earn some money. To be fair, I don't want to overstate my own importance. I was probably not the first person to make the argument that the NCAA's restraints on athlete endorsement deals violated antitrust law. And I was absolutely not the last. Over the past 9 years, we have seen very strong criticism of the NCAA's rules on college athlete endorsement deals, of preventing college athlete endorsement deals coming from throughout the spectrum from all different types of angles. Taylor Branch, the civil rights scholar, described the NCAA system as having a whiff of the plantation, where you had overwhelmingly African-American and low-income athletes doing the work and not sharing in any of the revenues. Numerous professors had suggestions about how to change the system to allow college athletes to sign endorsement deals. By the time 2012, 2013 came around, I had become very bullish and had believed that many, if not most, of the aspects of the NCAA principle of amateurism violated antitrust law. But others who might be seen as more moderate on the issue, including Professor Joe Patuto sitting in the front row here, who has served as a faculty athletic rep, had published articles, hers in Oregon Law Review, suggesting that even some of these restraints on endorsement of products need to come down from the NCAA. By about 2018, 2019, NCAA leadership decided they were going to have an independent investigation about how to handle and change and reform college sports. I use the term independent very loosely because they brought in Condoleezza Rice to write this report, who is currently a high-ranking official at Stanford University. And even Condoleezza Rice came back with the recommendation that it's time for the NCAA to liberalize its rules that prevent college athletes from endorsing products. Yet in the NCAA's own report, they came back and for reasons we don't understand said legal prevents us from moving forward with that now. I don't think anyone understands what that means. Well, the NCAA had a very long period of time in which they on their own could have come up with a proposal to liberalize their restraints on trade and allow athletes to endorse certain products. They did not do so. And what we saw happen effective June 30th of 2021, just over 15 months ago, is that when the NCAA would not act, many others of us acted for them. Between the Supreme Court case, Alston versus NCAA, which called into doubt the ability of 1,200 member colleges to maintain restraints of trade of a wide variety, and made clear that the NCAA member schools were subject to antitrust law, to a number of states led by California passing bills to ensure that the athletes in their state can endorse products. Many of us did for the so-called leaders of the NCAA what they were not willing to do. We, in essence, forced upon them necessary reforms. And of course, they were not perfect. and perhaps they have not been enough, but it has led to the system that we see today. So what I'd like to do in my brief talk today is I'm going to talk briefly about the financial status of college sports in America. I'm going to explain exactly the process by which various states, beginning with California, passed their bills, which in essence overturned this cartel in an economic sense and led to college athlete endorsing products. I'm going to talk about the positives that have emanated from the name, image, and likeness era. And then finally, because I'm a realist, I'm going to express certain concerns, some that were foreseeable and some that may not have been, about the current system, and make some generalized proposals about moving forward. I generally don't speak with notes, but I do have one index card with a few numbers on it because I want to make sure when I present things numerically, I'm presenting them accurately. When we talk about college sports in America, it means so many different things. Men's football at the University of Oklahoma means something very different than fencing at a Division III college. So just to understand what we're working with from a financial perspective, to use the NCAA's own numbers, according to a 2019 NCAA budget report, Division I college sports brought in $15.8 billion in revenue, with $10.2 billion of that revenue coming from the activities themselves as opposed to student fees. Now, the reality is, of this $10.2 billion, almost all of this money comes from a very small subsegment of schools, somewhere between, we could say, 64 and about 128 schools, to throw two Fibonacci numbers out at people. To throw a few more numbers out here to make the point, the University of Texas, you could boo if you want, athletic program brought in over $200 million last year, with $160 million of that coming from their football program alone. Now, to illustrate this point, and I mean no disrespect for hockey fans here, there are certain National Hockey League teams that do not bring in $200 million, much less $160 million in revenue. I'm going to give this to you one other way. The University of Texas football program brought in more revenue last year than the Arizona Coyotes, the NHL team. That is the amount of revenue that comes in from a limited number of these schools. 64 colleges in this country have football programs that bring in $25 million or more, ranging from that $25 million range to over $200 million from the University of Texas. And all of these colleges I reference are technically nonprofits, which means they operate subject to a non-distribution restraint. What that means is, if you think about a for-profit entity, the goal is to keep costs down to maximize revenue for shareholders. And at the end of the day, you will see the shareholders that get the economic benefit from doing so. In college sports, due to the non-distribution restraint, all of the money that comes in is supposed to stay in the system itself. And some of it might be allocated from one sport to another. But the system itself also includes employees. What that means is, the more money that's generated from big-time college sports, the more that goes to those individuals that are classified as employees. And we get some absurdities as a result, with uncompensated, unpaid, and historically not allowed to endorse product college athletes. You end up having certain college presidents, athletic directors, administrators, and coaches that, while not technically shareholders, enjoy the proceeds or the profits as if they are. To illustrate that, in the National Football League, arguably the most powerful sports league in the country, an undoubtable commercial entity, there are 5 coaches that make $10 million or more per year. In college sports, there are currently 7 football coaches who bring home more than $10 million per year. Where does this money go? Nick Saban at the University of Alabama is paid $11.7 million. Darbo Sweeney, $11.25 million. So the system we have historically seen in college sports has had these coaches and athletic directors who've made many, many $1 million per year. And as far as the athletes, and you could debate the study, but according to a study that was jointly commissioned by the College Athletes Players Association, a group that wants to organize college athletes, and Drexel University, in 2013, 85% of college athletes were living below the poverty line. There have been some drastic proposals to change the economic opportunities of college athletes, ranging from completely free economic markets to unionizing college athletes. The name, image, and likeness movement was not that. The name, image, and likeness movement was aimed at one tiny little sliver of the inequity in the system. It was aimed at not even having colleges themselves share revenue with the athletes. It was aimed at allowing college athletes the same rights that are allowed to all other college students and all other human beings, frankly. The right to sell the use of your name and likeness, to grant that permission for commercial gain to third parties in exchange for the sum of money. So how did this happen? If the NCAA member schools refused on their own to drop their own restraint, how did we move to a period where they were in essence forced to do so? And the story here a lot goes back to California. And the person who probably deserves the most credit is a state senator from California, Nancy Skinner. Now, there are many different ways that you could track the concerted restraint of a private association to prevent their workers, here the college athletes, from endorsing products for money. The way I had suggested 20 years ago in my law review was straightforward. File an antitrust lawsuit under Section 1 of the Sherman Act. Allege that the 1,200 colleges were colluding in restraint of trade and getting a court to lift the restraint. In essence, ending the cartel in which any school that allowed athletes to endorse products would be removed from the NCAA, and thus leading to a system where schools would feel free to allow athletes to endorse products and athletes would feel safe doing so. But Nancy Skinner decided to tackle this in a very different way. She proposed a bill called the Fair Pay to Play Act. Now, the name might be a little bit misleading. This was not about direct pay. The proposed bill, which she co-authored with Stephen Bradford, stated that in the state of California, it would be a violation of state law for any college, public or private, to prevent the athletes at that college from endorsing products for money or participating in any trade association that mandated that result. In essence, we had a cartel that no school was willing to break away from because they feared being banned from the NCAA. And what Nancy Skinner's bill proposed was to make it a violation of California law to go along with that seemingly illegal conduct and force all of the California schools to no longer participate in that restraint. Now, I can't tell you what Nancy Skinner thought, even though I've come to know her pretty well, but she had worked with an economist, Andy Schwartz, at the time. And I think the notion was that this was not only going to help the athletes in California, but reasonably, if you know anything about cartel theory, and we could look at price fluctuations with OPEC that really make the point, that once one substantial member or several members of a cartel walk away from it, and there is no ability to sanction them, then the cartel will fall apart. Because in a free market, while it might be the Pareto optimal outcome for the colluding parties for nobody to engage in conduct, if one does, they'll all want to. Or stated in plain English, for those who I just got too economicsy for, if one school is going to allow athletes to endorse products, every other school is going to want the same edge. Well, Nancy Skinner proposed this bill in California, and the NCAA chose to respond. They didn't have to respond, they chose to respond. Now, this would have been a wonderful opportunity for leadership of the NCAA to, if they had not done so this far, to maybe on their own think about lessening certain restraints on college athlete endorsement deals, at least on the fringes. They could have asked for a short period of time to make additional reforms, but they asked for a very extended period of time. And rather than listening to the public's demand or Nancy Skinner's proposed bill, the NCAA issued a statement, which was probably the worst statement they ever could have issued. The NCAA came back and said that if this bill passes, they will ban from postseason play every single California member school that complies with new California state law. Now, the NCAA's leadership did this with the goal of trying to make Nancy Skinner's Fair Pay to Play Act go away. And the threat was at least initially persuasive. There were athletic directors at some of the large California schools, both public and private, that feared that with Nancy Skinner and others messing with the NCAA, I use that in quotes, that they would find themselves unable to compete with this association they wanted to be a part of. And they started encouraging their local council people vote against the bill. On July 8th or 9th of 2019, there was a hearing before the Education Committee of the California State Legislature on the bill. The NCAA had witnesses that spoke very strongly against the bill, talking about the parade of horribles that they believed would happen if athletes ever be able to endorse products. Their star witness talked repeatedly about how do we stop college athletes from endorsing marijuana, something he purported they were all going to want to do the minute the bill went through. Nancy Skinner had 3 witnesses, and I like to think the 3 witnesses did a little bit better. The first person who came to speak was Russell Okung, African-American, former first-round draft pick in the NFL from a low-income family. Mr. Okung talked about what it was like playing college sports being poor. The desire to be able to engage in business practices, to endorse products, to learn from doing so, and to make some money. How the college athletes were denied the same opportunity that any other student in the student body would have. And how he was harmed and many other athletes were harmed by forced to live, and not only forced to live in low-income ways, but not even given the opportunity to bring themselves out of poverty by endorsing products while they were there. The NCAA claimed that endorsing products might be good for football players like Russell Okung, but would add no value for the majority of athletes. Even though Nancy Skinner purported that some of the greatest beneficiaries would be young female athletes, especially in sports like gymnastics, where their fame was greatest in their college years. The second speaker was Haley Hodson. At the time, Ms. Hodson was a law student at UCLA. She has since graduated and is practicing law in New York. Haley Hodson went to Stanford University as a volleyball player. The NCAA had claimed there would be no opportunity for female athletes to endorse products in any form. Ms. Hodson, in testifying, talked about various opportunities that were afforded to her that she had to turn down to comply with NCAA rules. These weren't huge million-dollar options. One of them she talked about was the chance to endorse a line of sunglasses for unlimited supply of sunglasses. She explained how this was not a lot of money, but it was small benefits, and it would have been very helpful and desirable to some athletes. Those were the first 2. The final witness was the technical witness, which meant that that person was not speaking about personal experience, but was talking about a particular area of law. I was the final witness on that day. Several of the California state legislators were very supportive of the bill, but were inclined to vote against it, not because they thought it was the wrong thing. They valued additional economic freedoms for athletes, but they were genuinely fearful that if they passed this, their local colleges would no longer be able to compete in college sports. My role, and you guys gave me a half hour, the California State Legislature gave me 180 seconds. My role in 3 minutes was to explain why, if the NCAA banned colleges that complied with the California rule, that the NCAA member schools themselves would be in violation of Section 1 of the Sherman Act. Believe it or not, a good part of my 3 minutes harkened back to that law review note I wrote, perhaps when I knew nothing 20 years earlier. Now, in just 3 minutes, when the legislators spoke afterwards, one of the legislators said that my 3 minutes changed his vote, because the only reason why he was opposed was fear of the NCAA threat. And after hearing from someone talk about the antitrust perspective, his concerns were relieved. Much of what I talked about in those 3 minutes was this Alston case and how the NCAA was going to lose it 9-0 or probably lose it 9-0. And how this notion that the NCAA is exempt from antitrust law that NCAA leadership kept on saying does not even jive with case law. That indeed proved to be the case. Once California passed its bill, it was a matter of moments, days, not weeks, before other states began passing similar bills. Florida moved next. If California was seen as a state that was liberalizing things for college athletes based upon a progressive view, Florida's was a lot more in terms of freedom to transact business. And Chip LaMarca of the state of Florida got a bill through very quickly thereafter to allow college athletes in that state to endorse products as well. And within days, the chips kept falling. No state wanted to be the state that could not recruit college athletes as effectively because athletes would not endorse products. And by the end of June of 2021, more than 20 states had passed bills to ensure college athletes the rights to endorse products. On June 30th of 2021, the NCAA came out and said, we are these reforms and we're going to allow college athletes to endorse products. The humor can't be minimized. The NCAA didn't do anything. They could have threatened to ban California member schools and probably violated antitrust law, but at least tried it. But the NCAA was not going to ban California member schools and Florida member schools and South Carolina member schools and New York member schools and Pennsylvania member schools. So they did not what they wanted to, but was clear they needed to do. They said, we are no longer going to regulate third-party endorsements of college athletes. Individual colleges could disallow it. That's not an antitrust issue. There's no collusion. Conferences collectively could choose to allow that. That might not be a violation of antitrust law. That might not be market power. But the NCAA said it was going to step away. I don't give the NCAA any credit for this. I give people like Nancy Skinner credit for this. But 15 months later, that's in the world we now live. So what has this world look like? On the positive side, we have college athletes now who are endorsing products, some of whom are making real money. There is way too much being written in the media about who has the biggest endorsement deal. The reality is many of these deals are for $3,000 or less. But we have a wide range of college athletes who are now endorsing products. This has also led to opportunities for both male and female athletes. While football athletes are dominating the name, image, and likeness opportunities, if you remove football, 52.8% of all remaining endorsements are female athletes. So indeed, Nancy Skinner seems to be correct that this would create opportunities for women who play sport. And we're also beginning to see a little bit of what I suggested in my law review, that there would be at least some college athletes who, now that they could earn small amounts of money, choose to stay in school. And I think the best example is the University of North Carolina basketball team that made it to the NCAA finals. All 4 of their players with college eligibility remaining returned, including Leaky Black, who asked for a 5th year of eligibility, and he's returning. And Armando Bacot, who is a senior, both who now have name, image, and likeness deals. It is a step in the right direction, a step towards fairness. Criticisms, and I only have a few minutes, so I'll only go through a few. 1, I'm not convinced this goes far enough. It's an important reform, but we still have 100 to 0 revenue sharing in college sports. And for about 100 or so schools out there that are bringing in very real revenue, if there is money out there to pay your football coach $10 million per year, perhaps there should be something for the athletes as well. Another concern. The NCAA has cried wolf about a lot of things for a long period of time. And in crying wolf, they've lost an incredible amount of credibility. And that's fair. But one of the concerns that some people in the NCAA had was that when college athletes became able to endorse products, there would be some individuals out there that would exploit them. I do think that's a fair concern. I earnestly believe the college sports industry and big-time college sports had been the exploiters themselves, that they have been very exploitive to college athletes. They know an exploiter when they see one, but they're right. They are right. In the weeks after the name, image, and likeness reform, hundreds of people, most non-lawyers, most with no knowledge in the space, none of whom advocated for this change, decided they would now name, image, and likeness experts. College athletes are being bombarded by these folks trying to help them endorse products when many of them don't have any knowledge about the field itself. Big companies have jumped in. Again, folks who've had no role in ever promoting the well-being of college athletes under any circumstance are now there. Now, again, I blame the NCAA a little bit for this too. We need in this country sports agent law that actually protects athletes instead of college athletes, and instead of the colleges themselves. Most of sports agency law in this country, thank you, comes out of the Uniform Athlete Agent Act, which was promoted by the NCAA. This sounds like a bill that should be protecting athletes in our country against unscrupulous agents. Instead, this is law that requires agents to disclose certain payments to college athletes. Now that we're in a period of time where college athletes finally have the opportunity to endorse products, we need to update and modernize our sports agency law. We don't want a system where the college athlete has been able to lessen exploitation from one party, the university or the NCAA, just to be exploited by a different group. Overall, as I think our other panelists today will agree, the reforms in college sports have been a wonderful thing. Athletes, for the first time, have the opportunity to endorse products just like everybody else in society. And for some of them, it's even increasing their opportunity to stay in school. But 2 things to think about. 1, these reforms, while wonderful, do they go far enough? Do we need further mechanisms and further challenges to the restraints of college sports to ensure that those athletes that are the labor force at about 100 schools in a few sports that bring in $25 to $200 million a year are able to share in the fruits of their labor? As John Locke says, every man, and I'm going to add in woman, deserves the right to share in the fruits of their own labor. Do we need to do more? I think we do. And second, how do we actually protect the college athletes against people who are jumping in the name, image, and likeness space as quasi-agents and ensure that they're given reputable advice and there are sanctions against those that are in there to make a dollar for themselves instead of to protect their athletes? And I think that could be covered by updating sports agent law. So I'd like to thank you for joining me on this half-hour journey of chat from 2002 to 2022. I'm hopeful for those of you in the room who are thinking about a student note, that if you're passionate about this issue, you jump on it. I remain amazed at something I wrote 20 years ago at a point in my life when I think I knew a lot less than I did today, continues to have relevance. And whether it be college sport or anything else, if you're a law student here and you're passionate about something and you believe there's a need for change, think it, study it, write it. You'll be amazed. What might sound outlandish to some today might be the new reality in 20 years. I look forward to hearing from the rest of the panelists, and thank you very much.
Questions for Professor Upton? You can do that, but we'll bring on our next panel just because we were running to this time. So, thank you again.
Star-studded panel here. It's pretty amazing people. First, we're going to have Joe Patuto from the Nebraska College of Law. She's the Richard H. Larson Professor of Constitutional Law. She teaches sports law, has authored numerous articles on intercollegiate athletics, a member of the American Law Institute. She was an advisor for the National Conference of Commissioners on Uniform State Laws for the Uniform Collegiate Agents Act. She's a faculty athletics representative for the University of Nebraska and has served three terms on the Division I Committee on Infractions for the NCAA. Then we're going to have Meg Penrose. She's professor of law at Texas A&M University School of Law. She is a former faculty member here at the University of Oklahoma College of Law, and she's also a member of the American Law Institute. She's done important litigation work involving sports, Title IX litigation, Title VII litigation. And she has a BA in history from the University of Texas at Arlington, where she was on the varsity basketball team. That's a Division I school, Division I athlete. Then finally, we're going to have Jason Leonard. He's the executive director of athletics compliance right here at the University of Oklahoma and has been since 2006. He's a native of Perry, Oklahoma, graduated from OU with a bachelor's in business administration. Where he was a member of the wrestling team and was an All-American for the Sooner wrestling team. He got his JD from OU after that, and also currently today teaches an NCAA infraction seminar at the OU College of Law. Meanwhile, I, unlike some of these people, have all my NCAA eligibility remaining. So I've got that in my pocket. All right. So first, please, Joe Patuto. See, something happened that it went away.
And I just clicked into it, right? I hate to tell your professor that, but he's aged out under NCAA bylaws. So I am really pleased to be here today. I would like to say, and I think I should say, that the organization of this colloquium today has been exceptional. I've been on a lot of panels, and the students who worked on it, the faculty who worked on it, it could not have been done better. And for people who present and do things, it's just a welcome way of making life easier for us, which I'm always interested in. My view is whatever is easier for me must be correct. So Mark did a great job of giving some real strong context in the NIL space and what's going on. And I am going to click, if I can figure out how this clicker works. Where's the clicker? There you go. The NCAA from its inception until last year, in its bylaws, described what it was up to and what the bylaws were intended to do as preserving the educational mission of institutions and keeping, including college athletes as students, and keeping athletics separate from professional sports, so they had their own mark and their own market share or market popularity. And for athletes, that meant no pay for play, which was where we still are, and no national, no name, image, likeness. And I'm going to get this, as an aside, for many, many years, whenever we saw the letters N and I and L, they were NLI for National Letter of Intent. And anybody who works in the college space consistently does NLI when we mean NIL. So I'm going to try not to do that, but it's very hard to, re-educate oneself. I've got two pictures that I want to present in terms of what's happening. One is for those of you who have read The Three Musketeers. There's a scene in the book where the four of them, they don't do math any better than conferences, where the four of them are sitting having lunch with wine and having a chat, and over their heads are coming cannon fire, and there are bullets flying. And of course, in fiction, they don't get shot or killed, and they merrily go on with their lunch. That's one image that I can give you for what NIL and college sports have managed to combine to do. The other is, and I had said that at Big Ten conference meetings, there's a big boulder coming down a high mountain, and it's gathering speed and it's gathering size, and everybody just looks at it and goes on as business as usual until the boulder hits, and then the ability to structure and form what the solution should be are out of the hands of the colleges, out of the hands of the NCAA, and what they're doing is playing catch up in a different world. That's still going on today. The NCAA has now devolved into bylaw authority at the division level, and that's been the history of the NCAA, dividing and subdividing and dividing and subdividing, each time to give the schools that are making the most money and have the most visible athletes. And of course, here we're usually talking about football, the autonomy to be making decisions for themselves. And we are now in a place where Division I, who's one of its sub categories of Division I, has the big schools with the money and the football powers, are now trying to write bylaws. But this picture of the boulder coming down and people just going on with business as usual is still happening. The NIL piece of this, in terms of what NCAA bylaws could be, should be, and will be, is simply one of a category of agenda items, and they are methodically starting in a place where if there was no boulder coming, might be a sensible place to start. And they're just methodically going through it instead of handling what is probably the most critical issue facing them right now. So Mark did and talked about some of the issues, some of how we got where we are. I am not going to do much except to say that the Board of Regents case, and by the way, you people here are, depending on your point of view on this, part of the instigators of the problem or part of the people who solved it. Oklahoma and Georgia sued the NCAA, and this was a time, for any student here, you wouldn't remember, when the NCAA limited the number of appearances a football team could could have on television. And the effort was to spread the wealth so that University of Miami of Ohio would be on television, as well as the University of Alabama could get visibility, would have more opportunity to recruit players, and on and on and on and on. Focus on providing the educational opportunity that sports are supposed to provide as compared to the fans and what they wanted to see. That case ended up in the Supreme Court saying antitrust violation, you can't limit. And now, of course, you can put on the TV and watch, 15 games or whatever the number is they're allowed to play now for any school. That decision really opened the floodgates. It isn't that money wasn't coming in before, but that decision really opened the floodgates on money. The last big announcement was that the Big Ten has just signed a deal for $7 billion over 7 years. You all are going to be in the SEC. They're going to sign a deal that'll be bigger than that coming up. So lots of money going on. What's happened is with the money, and you see the list there, there's more disparity between the A5 conferences. Those are the power conferences, Big 10, Big 12, ACC, SEC, and Pac-12. Bloated coach salaries, athletic palaces. I was at Oregon a few years ago, and their media room has leather chairs that are made of the same leather that Ferrari cars are made of. So the money gets spent. It's like me. You give me money, I'll find a way to spend it. It doesn't get saved. Very little of it goes back to the campus. And most schools, despite Mark's picture of what the revenues are, have to take money from the campus to survive. Some, like Rutgers, a lot of money from the campus to survive. They're all in an arms race. And the money that they're getting from these contracts is not enough. So we see more and more commercialization, exclusive licensees with regard to athletics department sponsorship. And now most schools, certainly the big ones, outsource marketing. So they no longer have a marketing department that goes and finds sponsors and does all that. They work with Learfield or some other agency out there that does the marketing arrangements for them. So they become, the picture is less and less of a piece of an educational institution, the way the law school would be or the med school is, and more something that looks like a financial enterprise that's operating for different reasons. And doesn't seem to fit well within the educational model. The concerns that people within athletics had with regard to NIL, I do not think were makeup. They believed them. And many of the concerns were real in terms of what might occur. And I give you a list of some of them here that were expressed at the time. And I'm going to move on. Some of them, athlete agents, the argument has been competitive effect. I think the jury is out on some of that, on the extent to which agents will corrupt the status of college athletes and college athletics, and the extent to which they will help. But there are certainly war stories, some of which are probably accurate, as to the influence agents are having already. And anybody who watches college sports knows the number of football players that opt out of bowl games on agent advice, that they don't want to get injured and injure their opportunities in terms of a lucrative contract for the pros. Mark talked about athletes being exploited. Kids today don't understand money, and athletes are no different. Don't understand the present value of money. Don't understand that if you're going to get a scholarship to go to Stanford and it costs $80,000, and you're going to get a scholarship to go to maybe Mississippi and it costs $20,000, and it's covering everything, that it's the same aid, even though one looks like it's more money. That I think is happening. Their universities are offering financial aid or financial acumen education now. There's some of the agencies that are out there working to provide NIL opportunities for athletes are also providing financial education. How well they're doing it, I don't know, but they're at least trying. I I'm not going to go through some of these because of the time. I'd be happy to do it later. Conflicting with university values. That was a concern at the time. It may well prove to be a concern, but right now I don't see any evidence that athletes are signing contracts that a university would say they shouldn't be signing in terms of what they're endorsing. And I haven't seen anybody endorsing firearms. If they're endorsing alcohol, well, schools are providing beer and in the stadiums now anyway. The last one on that list, donors and others only have so much money. So if it's going, some of it is going to the players, there may be less room for universities to make money. Probably will turn out to be true, but it may be true just at the margins. The concern with an athlete endorsing a product that conflicts with a campus exclusive licensee is a concern that everybody has. Some schools are saying you may not do it. Other schools are working with their outsource agency that's handling marketing to try to minimize it. And of course, to the extent that there are those conflicts, the exclusive license contract that a campus is going to have is going to be worth less money. But most of the, there are two worlds in athletics, and there probably always have been. It's football and maybe basketball, where the athletes, certainly at an A5 school, have a lot of media visibility. Those programs bring in a lot of money. The question is, are we corrupting admission standards by not holding them to the same standards others would be held? That's the picture in the world that everybody has. But the reality is most of college athletics doesn't look like that. You have lacrosse players and gymnasts and volleyball players who are doing well academically, and they're not getting, most of them not getting the high visibility, and certainly their programs are not bringing in big money. For the NCAA purposes, football brings in big money, basketball brings in big money, and most of the others are subsidized in one way or another. So for those athletes, the athletes that are not football and basketball, they are getting small deals that are helping them. And I listed some of what's happening here. Often the deal is you get free products from the enterprise that you're doing an endorsement for. What is true everywhere is the more visibility the athlete has, the more worth the athlete has to a corporate entity, whether it's the car dealer down the street or somebody else. Money follows tweets. And we've got a volleyball player at Nebraska who's got a huge Instagram and Twitter following. And so her ability to sign deals is better than the athlete whose presence on social media is less. But the fact is that many of them are getting some money. They're not getting a lot of money, but it's helping in terms of what they're doing in college. What's happened in this area is the development of different kinds of arrangements to bring athletes to a particular NIL deal. The agency model, which is the one that I listed second here, is kind of a traditional model. The university has a university exclusive rights holder. A lot of places it's Learfield. And one of their clients says, gee, I would like somebody to come in and sign autographs at the car dealership today. There are other entities that have NIL platforms. They're out there signing athletes. They're not signing them to any particular deal, but they're signing athletes. And so the NIL platform matches with the exclusive rights holder to find athletes to endorse products. These are very heavily tied to a particular school. So the Learfield would be Learfield. I don't know who you use. Jason, who do you use? You got Lear. All right, so Learfield is the exclusive rights holder for Oklahoma. The NIL platform will have Oklahoma athletes on the platform that they're working with, and the deal will be to match the Oklahoma athlete with the Oklahoma, whatever it is, the commercial entity. That's one version of this, and right now there are exclusive rights holders that are matching, and I give you Open Doors and Learfield. They now have an arrangement where they're formally working together. to match athletes with endorsements. Collectives are the new player in this area. Collectives are the IRS right now has not said that they're not charities. I think the IRS is just sitting and watching at the moment. Collectives are, their members are former athletes, donors, or sponsors at a university. At Ohio State, for example, Schottenstein is a major player in the board for their collective. And Schottenstein, for anybody who knows Ohio State, is also the name on their biggest athletics facility that isn't football or basketball. It's a prominent donor name at Ohio State and Ohio State athletics. Often it's former players, and usually it's football players here. So you have the collective, and they are explicit that one of their aims, maybe their prime aim, is to help the school recruit athletes. They make they're not hidden about what they're doing. They collect donations from fans and boosters and others at the university. The fans or boosters right now get a charitable deduction, because what the collective then does is locate charities for whom the athletes will work. Using the money that the fans from the school have provided, it's matched with a charity in town. Often the charities are, excuse me, identified with the university. At Nebraska, for example, there are 3 charities that the major collective uses. One of them is run by Tom Osborne. A second one is a foundation that's run by former football players. But anyway, the collective will find the athletes, pay them out of the money that it's provided. The athlete then works for the charity. Many of these right now only work for football and sometimes basketball players, although they say they will expand it at some point. Okay, then I will wrap it up. What I'm listing here now is some of what's going on here in terms of whether what the athletics directors were worried about is coming to fruit. You can see the deal at Utah. Nick Saban famously said recently that A&M cheated, and everybody that's going to play on the A&M football team got promised an NIL deal. There are people out there who do research in the area who say that the main factor for athletes right now and whether they're going to sign with the school is what it looks like for endorsement contracts coming up. So I'm going to leave the last slide up here while the next speaker comes up, because these are some of the issues right now that look like they're going to be coming to fruition. There may be a lot of women athletes who are getting a lot of money, but if the collectives or the agencies or seem to be university activity, then the fact that there's a big money disparity in the deals is going to have an effect on whether Title IX applies or not. Title IX right now, as long as the university is operating independently, these deals are not subject to Title IX, but the closer and closer they get, the more likely that there may be some impact. So anyway, I went over my time. I apologize. And the next speaker can now come up. Took your.
Can everyone hear me? Back at the University of Oklahoma, which is where I grew up as a law professor, and I have a great deal of gratitude to the university. My former colleague now, Dean Guzman, and I'd really like to start by thanking the law review. This is an incredibly timely and important topic at a school that probably is the most appropriate place to be hosted. The name on your law school building, being Andy Coates School of Law, he has a great deal of influence in this area because he helped with that NCAA versus Board of Regents case. So we all owe him as well a debt of gratitude. He's the dean that shepherded me through tenure, so I have a lot of gratitude personally. But in this space, he was a different thing. I come to you today also the former college athlete, one who was initially opposed NIL, and I'll explain why. I was a 5-year full scholarship athlete. I could not have afforded to go to college. I got to travel the country. I had a first-rate education, but in the law school with 0 debt. I learned discipline. teamwork, how to get along with people I didn't care for. I competed at the Division I level. I have college, I had clothes and a wardrobe. I was well fed, and it was in 1984 at a small Division I school for men and fashion. So I was a voice that had some reticence about the exploitation notion. My sister was full scholarship athlete at Mississippi State University, 5-year athlete. She left that university with 2 degrees, paid not a penny. Traveled the country. Met her husband, also a scholarship athlete. We have 3 nephews that were 2 college football. I have nephews. College football athletes, Division I, Division I basketball athlete. My niece just graduated from the University of Oklahoma as an athlete on the gymnastics team. She left with 1 national championship, 2 runner-ups. 1 would have been probably a national championship, but that was the year of COVID. She took with her not only an OU degree and boxes of clothing, and international and national travel, and fully funded education, but a job because she was an athlete at the University of Oklahoma. So make no mistake, those of us who play college athletics, many of us, not all of us, because again, I did go to a big school. I went to the University of Texas at Arlington, not the University of Texas or Texas A&M or the University of Oklahoma, but I did get to play here. We took with us value. So I also was a voice and continue to be a voice that there is value in being a college athlete. You get to keep the shoes on, you get to keep playing, you get training and discipline and tutoring. I wouldn't be here without college athletics. All right. So I came at it originally, I'm a no NIL person, because even though, as Professor Mark said, yes, I was below the poverty line, but let me tell you, I wasn't poor, and I had everything taken care of. Now that was one experience, and anecdotal experiences are bad evidence for lawyers. So as I give my story, please take caution. But now that NIL is here, I've flipped the script. There are 2 things that name, image, and likeness have opened up, or the 2 prohibitions, right? President Owen said, these are these opportunities to make, and I would want to use your phrasing because I think it was really important. Many people thought NIL would be the ability to endorse products, right? If you watch All American on the CW, or now I don't know where I get it, but I'm here behind. They're doing NIL, like it's now, and you see these football players repping sunglasses or weights, an athletic gym, and you're watching these young men navigate the space. In reality, that's not where we are. It's just not. So I'm going to talk about NIL from a different perspective and where I think the heart of the matter lies, and that's these collectives. All right. The 2 prohibitions right now on name, image, and likeness is it can't be direct pay for play. I can't just pay you for your success, and if you're hurt, stop the pain. So there can be no direct pay for play. And 2, you're limited to fair market value. Okay. What is fair market value? That is, from my new perspective, right? I'm a new convert. Newcomers are always the most dangerous. For me, fair market value is whatever the market pays. I don't want to see this a regulated industry because we're not regulating, as you said, the Nick Saban versus Dallas Sweeney. If you look at any study on the top employee pay, who is paid in nearly, I think it's 47 states. It's either the men's football coach or the men's basketball coach, right? So your top state, the highest earning employee is generally attached to the athletics program. Well, as we learned, athletics brings in a ton of money. When the code program changed the landscape on college television, Notre Dame, which is where I got my second law degree, went to NBC, where they still sit. Those of us who go to Notre Dame call it the NBC, the Notre Dame Broadcasting Channel, right? Let's say what Notre Dame does with that money. They put it back in the scholarship programs. I had 2 fully funded years of law school at Notre Dame, left owing 0, also got a stipend to live. So again, big fan of Notre Dame football, big fan of the athletics. It's not just that the universities are burning through the money. Sometimes they're putting it right back into the institution, which I think we should all value. As a law professor, I'm going to tell you, when I was here at OU and OU won the national championship, our applications went up dramatically the next year. If you want to look at another area where football programs influence, go look at U.S. News and World Report. Go look at the top 50 schools. Outside of the Ivies, look how many of them have really good football programs. Texas A&M's down in the top 50. I'm going to say it's all faculty, but we also have a very, very successful athletic program. Collectives, fair market value, that's the point of why I'm here to talk to you about this. Roughly 35 years ago, when I was in Dallas, Texas, roughly 35 years ago, the SMU program received the death penalty. Shut down. 1987, no more football. 1988, you can play, practice, you cannot play in a contest. The crime, Eric Dickerson, among other athletes, allegedly was given a gold Trans Am, although the rumor is that they became from Texas A&M, not SMU. It doesn't matter. One thing that was happening, and it wasn't just at SMU, it was in many of the Southwest Conference schools, pay under the table, boosters, direct payments from boosters. These kids were getting envelopes in their lockers. It came to the surface, and in fairness, SMU in 1985 was already on probation. So the fact that they were just incorrigible meant that the NCAA had no offer. So what did they do? They shut it down. They broke the program. It's actually one of the reasons SMU and the entire Southwest Conference broke up. We're talking today about conferences switching. SMU was really conferences. This hurt SMU's entire program, and I would say it has a ripple effect of the academics. People that want to be associated with your university, the quality of applicants you're getting. So 35 years ago, that gold Trans Am brought down SMU. Fast forward to April of this year, SMU football, Tony up on Twitter has a picture, and it's the gold Trans Am. If you haven't seen it, you've got to Google it. It's now SMU broadcasting. We've got a collective. Now, it's not associated with the university, right? It's third-party boosters. These same people brought SMU down are now lawfully, under the rules and new regulations, providing $36,000 per football player and men's basketball player in their collective. You go to school there as an athlete, you get $36,000. What do? You turn around, you do charitable work. Fair market. Here, the American Association for Law Schools this coming Monday is having a panel on this precise issue of fair market value. As I said, I want the unregulated market. I saw an author recently said we're 18 exits past the wild west. Now I just want to see it play out. Okay, I want to see what this means. This panel we're having on Monday, the Matador Club, which is the collective associated with Texas Tech, agreed to pay all of its men's football players $25,000. All. So one of the gentlemen on my panel coming up Monday said, "You tell me that the lowest recruited lineman for Texas Tech is worth $25,000." And I said, "He is. What do you got? If they're all getting it, that appears to be the market value." So you have the Matador Club giving $25,000. You have SMU men's basketball, men's football. Matador Club is also giving the women's basketball club, the women's basketball players at Texas Tech. They're giving them $25,000 as well. So there's some of the change. Now let's go to University of Texas. It's paying their offensive linemen, the collective is $50,000 a piece. You could leave your undergraduate institution with $250,000 if you stay for 5 weeks. Now, coming in, and Texas got 3 of the top 13 linemen in the nation because of this collective activity. Arch Manning, and the last name should be familiar to you, he has a famous uncle. Arch Manning, currently in the top 100 NIL, and we have a tracker on free.com that's tracking the value of NIL images, the athletes. Arch Manning hasn't even played a snap in college football, and he's ranked number 1 also has a rather famous last name. It's Bronny James. He's number 1 in NIL deals right now. He hasn't even set for the college. Next 2 athletes: Ohio State quarterback, Alabama quarterback, number 5 in LSU gymnast. 2 gymnasts are in the top 10. So I'm someone looking back and with gratitude to Nancy Skinner that maybe this NIL opportunity is going to give female athletes their due. As I said, my niece graduated here in the gymnastics program, and they had gymnasts like Maggie Nichols. If you're from Oklahoma, let me tell you, if they would have had NIL during Maggie's time, she would be set. She will be anyway, a very talented young woman. But in short, market value is whatever the market is willing to pay, but we need to be paying close attention to these collectives because they are precisely what we outlawed 30 years ago. And the concern is they're being used as recruiting tools, and we just want to make sure that they're not a way of corrupting the competitive nature of college athletics. Thank you.
Yeah, absolutely. So I'll try to use this mic. If I don't speak loud enough, please let me know. I'll speak louder. I truly appreciate the opportunity to be here today. I'm a big fan of Joe. So when I started in compliance 16 years ago, I would read committee on infractions cases. Joe was a hammer with the committee on infractions. I don't know, were you on the Oklahoma case? I don't think you were. We're in the same conference, so that was the only disqualification, but I'm a huge fan of your athletics director. So I'm appreciative of being here today. I think there's a benefit of going third. I think I get the final say. I've always wanted to be a judge, and this is my opportunity to be a judge. I'll just start by saying that I am a huge fan of the concept of NIL. I support it. The University of Oklahoma supports it, but there is a lot of abuse that's going on in this area, and hopefully we'll have a little bit of time to get to that today. What happened to Jeremy Bloom years ago was unfortunate, and it clearly showed back then that we needed to change this area for college athletics. It seems like, based on the speakers, that this has taken 2 different tones. There's the college athletics model, which we could debate and talk about all day. And then there's also NIL. I'm going to focus on NIL, but what Mark brought up, I think, is also college athletics model, which we could have a healthy debate about that. Just start with some of the statistics in Oklahoma. We have a state law. It was written by our athletics compliance department at the University of Oklahoma with collaboration from Oklahoma State and also Tulsa. It was Senate Bill 48. It passed in Oklahoma on May 28th, 2021, and it was approved by the governor the same day. What's interesting about that state law is that somebody put in a provision, and I don't remember who it was, and I can't take credit for it because it was not me, but it was section 25 of our state law that basically states that every institution in Oklahoma has the ability to determine a date on or before July 1st, 2023, upon which the provisions of the Student Athlete Name, Image, and Likeness Rights Act will be recognized by that post-secondary institution. To date, Oklahoma has not done that. The University of Oklahoma has not done that. To date, my understanding, there's no institution in the state of Oklahoma that has done that. 2 reasons why. One, with NIL changing so fast and so frequently, we want to be as flexible as possible. The second thing is the NCAA, as Mark mentioned in his opening, changed the provisions on NIL as of July 1st, 2021. And so we didn't have to enact it. So currently the University of Oklahoma works underneath a policy. And obviously you guys know policies are a lot easier to change than state laws. There's been a lot of states that have enacted laws that have already repealed those laws dealing with NIL. One specifically is the state of Alabama. Shouldn't say specifically, ironically. They have changed it very quickly. It's a couple of NIL statistics that I think would be informative to all of you. I read every day in reference to NIL just to stay on top of the times. These statistics should tell you kind of where we're going and for purposes of NIL. There is a publication called Recruiting is Now All About NIL, Power 5 Student Athletes / Recruiting Decision Criteria. What kids make their decisions on in terms of going to a college to play college athletics. This is written by a professor, I think out of Vermont. He interviewed over 1,000 Division I college student athletes. 29% of the student athletes surveyed said NIL is the #1 criteria they look at in deciding where to go to college. 29%. Almost 30% of student athletes don't decide based on team culture, coaching, academic reputation, facilities, alumni network. None of that is as important to them as what am I going to get from my institution, from your institution, and for purposes of NIL. One short year, 18 months, changed that dynamic tremendously. Another statistic, that I think is interesting based on what Mark had said earlier today is that 69% of student athletes don't know what the Federal Trade Commission is or its relevance. Okay, 81% of student athletes say they have never heard of the Federal Trade Commission's endorsement guides, and 67% of the student athletes who post on social media for brands do not disclose their sponsor relationship. The FTC's mission is to protect consumers. The FTC has developed these endorsement guides to protect consumers. And unfortunately, our student athletes, including University of Oklahoma, social media is where the younger generation is at. That's where they're making their money. And they're not even aware of the rules that are associated with what they're doing, in addition to paying taxes on the money that they receive. Student athletes must always disclose if they have a relationship with a sponsor so people can weigh in on the value they add. That's the FTC's guides, and they're not even aware of that, or at least 69% are not aware. NIL deals at Oklahoma, just so you guys know, our athletes have entered into 1,161 transactions, approximately $2.5 million. That's what I would call true NIL. Okay, we have a collective. Our collective only has one deal as of today. So this is what I would call, again, true NIL. Of the deals, 51% of the transactions are in women's sports, and 49% of the transactions are in men's sports, which is a good, healthy balance. Each team has at least one NIL transaction. Here's where it gets kind of interesting. Men's football has the most transactions in men's sports at 490, and the largest dollar value of any sport at almost 2.1 million. So of the 2.5 million, our football team is making 2.1 based on the 16 or so months since NIL was enacted. Our women's softball team has the most transaction in the women's sports with 429, but the dollar amount is only 198,679. So those are trends that you can think about for purpose of NIL, and you can see when it comes to where the deals are going and what student athletes are asking for out of high school. Football is the driving force. Our football team obviously is the driving force here at the University of Oklahoma. Mark had mentioned in his opening, and I thought it was just important to mention, I didn't have it in the presentation today, but at Oklahoma, we have 21 sports. We have one sport that makes money. We have one that breaks even. That one sport that makes money funds all of our other sports. And Joe hit on this in her presentation today. So when we talk about athletes being able to profit off NIL, I'm 100% in favor of that. But if you start providing money to football, you have to provide money to all athletes, as you guys know from Title IX, from your law school classes. And the model is going to have to change to accomplish that. The college athletics model is going to have to change. And I'm not saying it should or shouldn't. I'm just basically here to present the facts on both sides. Our compliance operation monitors NIL. We have an entirely new, distinct standalone operation for NIL, Toby Baldwin, who used to work for me for 13 years, is now in charge of our NIL operation. I'm not going to go down into it too deep because I don't think we have a lot of time. But long story short, again, OU has a protocol, has a policy. We don't have a law that we have enacted. Our deals basically are similar in that they say you can't have inducements, can't have pay for play. You can't have deals within certain industries such as gambling, banned substances, assault weapons, et cetera. And that is very fluid. Our protocol is very fluid. And we are watching the national landscape. We're watching these collectives because when it comes to college athletics, it's important to be successful. It's important for our teams to be successful. And we don't want to go and handcuff ourselves with a state law or a policy that puts us at a disadvantage to Texas A&M or Nebraska. And that's one of the things, again, in talking about the college model, different from NIL, that's really unique. Mark hit on that a little bit earlier. One of the most important things I think that our NIL department does is educate our student athletes. Financial literacy is a big deal. Obviously, we're going to talk about the FTC tomorrow, maybe a little bit more than we have been in the past. We've educated them on taxes and the fact that they have to pay taxes. Most of our deals average around $1,500, but they still have to pay tax on that money. And so we want to make sure that we focus on that. In terms of the rise of the collectives, I think it was not assumed that something like this would happen, but I think that we're being a little naive to think that it wasn't going to. If you look at the creation of the NCAA back in 1905, it was as a result of a lack of rules that protected student athletes on the football field. And the NCAA was initially called the Intercollegiate Athletics Association. It was later turned into the NCAA in 1910, but it was based on the creation of rules to create more of a level playing field between all institutions. That model has created what we all enjoy on any given weekend. It was a good model. However, we've lost our way. Our manual now, our NCAA manual with the rules is up over 500 pages. Joe, I think that probably your manual when you were the FAR at Nebraska was around 50 pages, give or take.
I don't know.
Maybe a little bit more than that. Unfortunately, when it started, we had limited rules. So what we've done with NCAA, we started regulating a lot of things that probably shouldn't be regulated. When it comes to NIL, we probably absolutely should regulate this area. We've talked about Meg's talked about collectives already. This is basically just a donor component that basically circumvents inducements. So kids come and play at an institution. When our kids come on official visits or unofficial visits, they're asking about what am I going to receive from NIL? You know, if it truly was NIL and it was truly based on market value, the institution would not be answering that question. It's the market that provides that sum of money that they would get. When it comes to the state of Oklahoma, our OSSAA just implemented guidelines. Again, we don't have a state law that we have enacted, but our OSSAA, which is Oklahoma Secondary Schools Activity Association, just issued guidelines, and they have the same guidelines that we have, or very similar to the guidelines that we have at the institutional level, which is no pay for play, no inducements for an individual to come play at your high school. So if we have those guidelines at the high school level, it's happening at a very young age, and it's continuing on to a greater degree at the college level. You had mentioned Bronny James. Oregon changed their OSSAA rules on the same day that he signed his deal with Nike. And so all of these schools at a high school level are implementing these guidelines, but they also want their athletes to be able to profit off of NIL, and they don't want to be left behind. And that's what's going on at the college level also. So I'm going to stop there. I have a lot more. Hopefully some of it will come up in the questions, but in the interest of time, I'm going to stop.
One of the big rule book, as many of my students here will know, that's almost as long as my syllabus. I think that we probably have time for maybe one question. Maybe two if it's super short. Anyone?
Within the ranks of is there any acrimony from one team to another sport, or even within one team, you see such a disparity of compensation that, you know, the star quarterback is getting versus the grunt lineman who's doing the heavy lifting for the team? There's such a big difference. And if so, how are teams working through that?
Yeah.
Whoever.
I'll do the first crack at it.
Yeah.
That's what you're going to get. It's interesting because it's a weird dynamic of the compliance profession. Because it's our responsibility to enforce and seek the rules. And our responsibility to determine market value. And I love kickers and punters, but they're not worth as much as star quarterbacks in terms of the market. And so you haven't seen enforcement get into this space yet. There's been a lot of, I think there's 3 different directives that they've given out. Obviously, there are state laws that allow what's going on to occur. We don't have a state law that we've enacted. But it puts us in a weird situation because we don't know what we don't know. We don't know what we can't do. And I don't think I'm going to be the first to file a violation on market value and everybody's getting the same thing. When other institutions have state laws that protect those compliance individuals. Now, in terms of the locker room, which is a whole different dynamic, it's probably better that everybody has the same value, everybody gets the same amount. But again, that is completely inconsistent with what I would again call true NIL, what the meaning of NIL was supposed to be.
12 seconds. Any quick responses? I think we're out of time.
Got a quick question.
It's 5 seconds.
Do you foresee unions as the ultimate resolution?
Yes or no, down the line.
I do not think that's a good idea for the applicant.
Much of the.
Casey Stengel said never makes predictions, especially about the future.
Testing, can you hear me? Testing, can you hear me? Okay, great, thanks. You look great on video up there.
Okay, if we can have everyone start taking their seats, we'll get started with our next panel. All right, welcome back, everyone. I will be moderating the second panel of the morning. Quick reminder for those just joining us, the format is we'll have both of our panelists present their research and thoughts, and then we'll open up the floor to audience Q&A for our panelists. For presenting first today will be Professor Catherine Kiska-Schultz. Unfortunately, due to the airlines, which one will go unnamed, but they, due to some travel complications last night, Professor Kiska-Schultz was unable to physically be here in Norman, much to our dismay and her dismay. However, one of the upsides of the pandemic is we now can Zoom, and so we are going to Zoom her in so we can still hear her wonderful presentation. She's an associate professor in the School of Accountancy at Clemson University. She teaches business law and tax courses at undergraduate, MPA, and MBA levels, and the majority of her research focuses on the intersection of business law and tax, with significant interest given to the amateur collegiate sports arena. After Professor Kiska Schultz's presentation, we will then turn to our very own co-author, Professor Kit Johnson and Eric Johnson. Professor Kit Johnson is the Thomas P. Hester Presidential Professor here at OU, and her research concerns immigration law, and particularly the intersection of immigration law and business interests. Professor Eric Johnson is the Earl Sneed Professor of Law at OU, and his interests include intellectual property and tort law, with a particular interest in licensing and in the right of publicity, which is, what we refer to as NIL in the sports context. He has extensive experience in sports entertainment law as well that he brings to our discussion today. So with those brief introductions, we're going to, with fingers crossed that all technology works correctly, turn it over to our virtual Professor Kiska Schultz.
Yes, thank you. Do you all mind giving me a thumbs up if you can see me up on the panel? Yes, it looks like I got a thumbs up. Thank you so much. Nothing could have prepared me for giving this presentation from my home office today, just outside of Clemson, South Carolina. I was literally in the security line yesterday evening to head out to Oklahoma City and then to Norman when I got the alert on my phone that my first leg of my flight had been delayed by a number of hours, which was going to ultimately make me miss my connection. And the best they could do was get me out to Norman by this afternoon, which of course would not have allowed me to participate. So I first just want to say thank you to Megan Shanner and OU IT personnel. You have very quickly helped to turn this around so that I could still participate. And I can't thank you enough for that. I also want to say, Kit and Eric Johnson, it is my pleasure to do this with you. I wish we were doing it in person together, but you guys look great up there on screen. And so for what it's worth, it's really nice to meet you virtually. But today, I just want to talk briefly about name, image, and likeness with respect to Title IV, which probably most of you don't even know what Title IV is when I reference that. We all think about Title IX, and that's a big area of college sports. But Title IV deals with federal financial aid. And just a bit of a background on my interest in delving into this issue, I am part of one of Clemson's large undergraduate sort of consortiums at the university. And back in January, I was in a meeting where Jeff Holliday, who is the director of financial aid at Clemson University, made mention that he had been in a number of meetings, to include ACC meetings, where there were a lot of discussions and concerns about the role of universities in the ACC with regard to student athletes, NIL, and tax issues and federal financial aid issues, and whether and to what extent universities need to play a larger role in these issues. And after that meeting, I didn't know Jeff, but I called him up, and we have since had a number of meetings together talking about specifically federal aid. I've actually written on tax issues with respect to NIL and student athletes, but I had never delved into the Title IV issues. But as he and I spoke, and I've also had meetings with Bobby Couch, who is the director of Tiger Impact, which is Clemson's largest NIL collective affiliation, I really became very interested in this area, and it's not being talked about enough. And so I thought I would bring it to the academic attention with regard to this symposium, and certainly ultimately with regard to an academic paper. I will also say, I appreciate Mark bringing up Dabo Swinney. Yes, I am at the university where we have one of the 2 highest paid football coaches in the nation. I also have sort of a very personal interest now in NIL outside of academia. My oldest daughter will be signing her NLI very soon here in November, because she is actually going to be on Clemson University's women's golf team. And so she has been recruited for that. And of course, now NIL has a new and interesting meaning for our family because we just don't know what the potential possibilities are for her for that. And so all of this is sort of interesting and tangible for many of us. So with that introduction, I don't want to spend any more time giving a history of NIL. Mark Edelman did a fantastic job of doing that earlier today. I do want to just point down to the bottom bullet here and just say, you know, within this past year, it has really become more of a patchwork of state efforts to address NIL now that the NCAA has really relaxed its stance and kind of taken more of a hands-off approach, which has made this incredibly interesting. And as we've heard the term before, kind of NIL has become part of this wild, wild west because we don't have an overriding regulatory system at this point. And so that's made for some interesting dynamics across the United States with regard to NIL. And certainly we've also talked about a bit here this morning about the rise of NIL collectives. And I know there's going to be more discussion about that in the next panel. But it's really an interesting and fascinating area that has developed here just in the last year. Currently, there are more than 124 and nonprofit NIL collectives out there. And many of them are starting to develop affiliated relationships with the universities. I think Matador Club was brought up earlier, Boulevard Collective out of SMU, and then Tiger Impact, which is one of the many NIL collectives that are affiliated with Clemson. And while I fully support NIL, I think that it's an important step in the right direction for student athletes in the United States. Of course, not as all perfect, which if it were, we probably wouldn't even be having the symposium today, because there are certain issues that have to be dealt with moving forward. Certainly Title IX concerns, which was brought up earlier, recruiting concerns, which was brought up earlier, tax concerns, which I think there's been just a little pinch of information on that today, but definitely an issue that student athletes have to become aware of. And then for purposes of the remainder of my discussion here today, Title IV financial aid concerns. Now, something that I learned, which really hadn't been on my foresight when I spoke to Jeff Holliday beginning back in January, is that NIL earnings could potentially reduce or eliminate Title IV need-based aid for student athletes. Just some interesting data to share with you all. 83% of college students require some form of financial aid out there. And there might be, you know, some or many of you in the crowd there today who have been part of this percentage that has over time needed some federal financial aid assistance to get through higher education. Of those, 92% derive aid directly from federal student loans. And currently the US government student debt portfolio is at about $1.6 trillion. And that number derives from more than 45 million borrowers. What does that mean? It means a lot of people require federal financial aid in order to fund their higher education. And student athletes are not absent from that picture. Interestingly enough, only 2% of high school recruits actually receive athletic scholarships. Sounds like a really low percentage. Even when I researched it, it sounds like a really low percentage. But when you look at all the division, student or various division student athletes out there, only 2% actually get some form of athletic scholarship. And another really big number, almost 50% of student athletes require some form of need-based financial aid. So even though you have all of these student athletes out there, certainly not all of them are getting full rides at their colleges or universities. Many of them aren't getting any athletic scholarships to play sports. And then a large chunk of them actually require some form of federal need-based financial aid, which really brings forward this Title IV issue. So Title IV of the Higher Education Act authorizes the federal government to provide some form of federal aid, just a little bit of a background on where this all comes from. And you may be familiar with some of these funding options, for instance, subsidized or unsubsidized loans, Grad Plus, Parent Plus, Perkins loans, and then Pell Grants. These are some of the many more common funding options that are available at the federal level. And of course, again, I'm not out there to see how many of you are in the crowd, but I imagine that many of you, in fact, it's on my list to do this weekend with my husband, is to fill out a FAFSA form, as we have, a new entering freshman in college next year. And when you fill out that FAFSA form, students and their parents have to put it in their income, asset information, tax information, and what I found interesting, having not filled out a FAFSA in January when I began talking about this and researching this, is that when you enter that income, it actually derives from 2 years prior, what they call the prior year data to calculate current need-based aid. So whenever we fill out our 2023 FAFSA form for our daughter this coming year, we'll actually input all of our income, asset, and tax information from 2021. And I just wanted to point out that of all the items that you have to input into your FAFSA application, income carries the greatest weight. So understanding just a basic idea at this point of FAFSA and Title IV, student athletes that require Title IV aid may be okay today, but NIL contracts could impact the future ability of them to receive Title IV funding based on this prior year requirement. So a very simplistic example that I'm offering here, we have Pat, a sophomore student athlete who plays baseball, qualifies for Title IV aid during the 23-24 academic year. And then in 2023, Pat enters a $50,000 NIL contract. He then turns around and uses that money to buy a $45,000 truck, which may or may not be something that would be hugely surprising for a young person who all of a sudden has a lot of money in their pocket. In 2025, Pat may lose some or all of his federal aid if the weighted portion of his $50,000 earnings pushes what's called his expected family contribution, the EFC for purposes of FAFSA, beyond the point of need-based funding eligibility. And if Pat or Pat's family didn't plan for the additional out-of-pocket cost, they may not have enough money to satisfy this increased EFC amount that they will be required to pay in order for Pat to remain in school. And so had, Pat been aware of what the impact of his NIL fundings could have 2 years down the line, he may have been a little bit more frugal in how he would choose to spend that $50,000 with that now going towards, let's say, a vehicle. He doesn't have enough money in my hypothetical here to actually offset the amount of money that he's going to be required to out-of-pocket pay in order for him to continue at his institution. And this was one of the biggest concerns that Jeff Holliday and I talked about when it comes to Title IV federal aid. There is less concern at the university level of these student athletes who are getting $1 million deals, because it's really hard to spend $1 million in just, let's say, 1 or 2 years. And they're less concerned about student athletes who maybe get as Mark mentioned, that average $3,000 NIL contract deal, because that may not push them into a spectrum of having a Title IV concern later on. But student athletes who are making a fair amount of money on these NIL contracts, but who still fall in that spectrum of needing financial aid, this is where at least Clemson University is concerned, that if these student athletes are unaware of the impact of their NIL funding on future federal aid, and they don't plan for this, they could find themselves in a bit of a problematic situation a couple years down the line. Well, the U.S. Department of Education became aware of these issues, and back in November, they issued some guidance, and the guidance is a little heftier than what I have here on this slide, but I'll just share some information. The U.S. Department of Education came back and said NIL compensation is considered taxable income, which is no surprise to anyone who has any background in taxation. They said NIL compensation reflected on a student athlete's Form 1099, which is your independent contractor or tax form, should be reflected in their adjusted gross income for FAFSA purposes. So NIL income is identified to be wages and therefore includable in that EFC calculation that I was talking about just a bit ago in my hypothetical. They also noted that NIL is different from athletic scholarships and complimentary room and board, which is not included for FAFSA purposes in income. And they also noted that it's the institution's responsibility to identify and resolve conflicting information that would affect a student's eligibility for Title IV aid. This was something that was also noted as a concern in these ACC meetings. To what extent do universities now have to play middleman in this regard if student athletes are not proactively documenting or making public where their NIL contracts are coming from, but the university is aware of it? To what extent do they now have to play the middleman, for FAFSA purposes, for IRS purposes? This has become a big discussion out there. And then if an institution is notified of a student's NIL contract, its financial aid office is considered equally informed, even though the NCAA does not require students to report NIL activities to an institution. Now, that goes back sort of to what I mentioned earlier about state laws sort of now being a bit of a patchwork out there. In South Carolina, our state law requires that student athletes keep their universities informed of where their NIL contracts are, but I would be hesitant to say that I know of all 50 states have that same requirement, but certainly some of these state legislations have come forward to say, well, we need to know where these NIL contracts are coming from. Some of that I'm sure is specifically with regard to what the ED has now issued, saying that institutions, may have to play some form of middleman and resolve conflicts if a student athlete doesn't disclose their NIL funding, let's say on their FAFSA applications that the universities then have in hand. So with all of this and just, briefly introducing this issue, a lot of this in my mind comes down to educating student athletes on their financial literacy. And I'm so grateful that Joe and Jason in the last panel brought this up, and that OU actually has, financial literacy education. I think some of the bigger institutions are probably moving in that direction if they haven't already, but certainly there is no guarantee that all of these institutions out there with these student athletes are offering some form of financial literacy education. I can share that Florida actually passed a law that mandates that their state universities provide financial literacy workshops to their student athletes, but that is the exception rather than the norm across the United States to have a mandated requirement for this. And so one of the ideas that I have come up with is really looking at this from a more global perspective, not just punting this to institutions, though institutions will have the closest relationship to student athletes, certainly, but to really make this more of a tertiary approach with the NCAA, institutions, and these NIL collectives, and together kind of engaging student athletes to become more aware of their financial responsibilities as these NIL earnings opportunities arise. And so as I have here, the NIL focus should not just be on directing, earnings and say, oh, where's all this money coming from? Hey, but let's, ensure that we can, recruit properly with all of these NIL earnings opportunities. But we also need to equally look at the increased fiscal knowledge that student athletes are going to need as they tread in these new waters. And so from an NCAA perspective, the NCAA back in 2019 did launch a pilot program through Kansas State and the University of Texas at Austin that evaluated student athletes' financial literacy levels. And they did have some findings that suggested that student athletes have pretty limited exposure to financial management prior to entering college. They exhibit low levels of financial literacy. Only 21% of them have a monthly budget. 42% have money management anxieties. And with all of that in place, an interesting 72% actually have an interest in financial literacy. They want to be better at this, but they just don't know how. And so the NCAA, coupled with iGrad, which provides financial literacy, they've also have another program, a digital program, and let me just think about what the name is. I think it's called How Not to Suck at Money, which is more of a financial literacy game that student athletes have access to. But again, none of these, whether it's iGrad or How Not to Suck at Money, none of these delve into financial literacy for NIL funding as applies to Title IV financial aid. And so one of my recommendations is that the NCAA really updates their efforts internally with these digital programs to to better educate student athletes about the impact of NIL funding on their Title IV financial aid. That can include a recommendation of some educational nudging, not just offer these programs, but provide some educational nudging through, personalized text messaging. That's a lot of research out there that educational nudging is sort of an up and coming area. And so I recommend that, we take that area and move it into the NCAA's effort. It's going to be hard for them to be more personalized with student athletes, given that student athletes are across the nation. And so that will be hard for them, but they can provide some nudging of efforts to help remind students about the importance of some of these programs that are being offered. In conjunction
Right.
with,
Oh, sorry. If this is your last slide, Professor Kiska-Schultz, go ahead. Otherwise, I was going to pause so we have time for questions for you at the end as well.
no problem. Let me just show you. I also make recommendations about the institutional and NIL collective. So there you go. I'm wrapped up. And I couldn't help but offer this last picture.
Perfect. Well, we're going to go with Professor Johnson and Professor Johnson, and then Professor Kiska-Schultz, if you want to just hold on mute, and then with questions, we will circle back to everyone. So.
Well, Professor Kit Johnson and I are going to talk about international students and NIL. There's a big perceived problem with that because international students, student athletes, most of them are here on what's called an F visa, which has a prohibition against most forms of employment. And what we've found is that there's many assumptions that are being made about NIL and international student athletes that we think are unwarranted. So one problem is that people speak of NIL income and associate it with work, employment, services. People speak of NIL activities. That's not really what NIL is all about. And some people even suggested, I saw this in John Holden's paper, that there's something wrong with paying people NIL money without associated work or services. But really, if you take it back down to basics, that's what NIL is all about. So the reason that you can be compensated for NIL is because you can sue people for using your name, image, likeness without permission. That's an intellectual property doctrine called the right of publicity. I have with me, because I borrowed it from my Museum of Intellectual Property in the library at OU, and I hope you'll let some of you will let me take you over there after the symposium for a tour of the law school and my little Museum of Intellectual Property. But this is the original signed contract from what's often regarded as the first right of publicity case, which is Halen Labs versus Topps, Second Circuit, 1953, which was about baseball cards. And this contract doesn't say anything about services, anything about work, anything about employment. It just says we're going to pay you a certain amount of money if you allow us to use your picture and signature and name on baseball cards. So that's what NIL really is it's money that you get from someone in exchange for giving them permission, which we call a license, to do something that otherwise you could sue them for. A license is consent, it's permission. It doesn't have to, it's not a contract, it's an affirmative defense against a right of publicity violation. So, for instance, if some student athlete is paid to do a television commercial and they are paid to film the television commercial, then you are paying them for their services, I guess, to stand in front of a camera. But part of that you're paying so that they won't sue you when you air that television commercial and use that footage to show them endorsing your product. So at the end of the day, when it comes to international student athletes and whatever the restrictions are of their F visa, which will be Professor Kit Johnson's job because she's the immigration attorney, immigration professor, I'm the intellectual property person. But whatever that is it doesn't need to be associated with work or services rendered or labor or employment at all. You can just pay someone for the ability to use their name. I think they're already doing this in Arizona by selling jerseys with college athletes' names on them. They can get income from that. They don't have to do a single thing at all. And that should somewhat simplify the picture for collectives that want to get money to student athletes.
So there are a number of international student athletes in the United States, and the vast majority come on what is called an F visa. And the F visa does indeed have pretty stringent restrictions in terms of employment that a non-citizen can undertake when they're in the United States. So there are restrictions. In the first year, you can work on campus, but only so many hours and only so many kinds of jobs. And then after your first year, if certain things happen, you can get authorization to be employed outside of campus. Now, the consequences for undertaking employment that is not authorized when you are a non-citizen are high. If you engage in employment that is not authorized, that is a deportable offense, right? So you can be literally removed from the United States. Obviously, that downside's really high. And I think that's why people have been so cautious in the area. And there have been so many comments about the fact that, oh, international students can't do this. They can't do this. They can't do this. But the reality is that employment is the cornerstone. So in the F visa, it talks about what you can do as on-campus employment, what you can do as off-campus employment, and employment itself is not defined in the F regulations. Secondary sources, so the Immigration Law Service, law reviews, have said that self-employment is prohibited. But all of those sources cite a Sixth Circuit case from 1983 called, and I'm going to butcher this name, but Wedesinge, call it Wedesinge, from 1983. And indeed, it does say that, right? That's what this case says, is you can't engage in self-employment. That's a violation of the F visa. But three things have happened since that case was decided. First, the underlying regulations that led to the decision in that Sixth Circuit case were changed 11 days after that decision. So in 1983, the law changed. So before 1983, we had law that said you cannot engage in off-campus employment, quote, either for an employer or independently, end quote. That language was jettisoned in 1983, and it has never returned to the regulations. Second, so 1983 is the Sixth Circuit case. In 1986, Congress passed something called the Immigration Reform and Control Act of 1986. This introduced a definition of employment into the statute, and it is in context of creating penalties for employers who hire unauthorized workers. In that context, employment does not include independent contracting, specifically excluded. And then the third development to be aware of is that the Supreme Court said in 1989 in CCNV versus Reed that where employment is undefined in a statute, it means the common law agency conception of it, which is not any compensated work, not what you would call independent contractor labor, but essentially just real bona fide employer-employee situations. And so I think that there is a misunderstanding or a failure to kind of look deeply into the issue of what it is that non-citizen athletes can do and what they can benefit from while playing in the United States.
So since we actually have a little bit of time here, let's go over a few hypotheticals. So someone sells a shirt with your name or image on it. You can sue them for right of publicity, misappropriation, unless you've given them permission, given them a license, in which case they have an affirmative defense. And if they want to pay you for that license ahead of time, they can do that. It's not compensation for labor. I don't know how the tax people will treat it. That's not my area, but they think it's labor. They're wrong. Doesn't mean that will convince them. But if you promote those T-shirts on TikTok or Instagram so that you can drive up sales, That is some amount of work. You're doing some work with your thumbs, I guess, but it's certainly not employment. It's not a bona fide employer-employee relationship. By the way, CCNB versus Reed, the case Kid talked about is a copyright case. It's a cornerstone copyright case. So actually it kind of makes sense in an intellectual property context. So that's some work, I guess, but it's certainly not employment, and it shouldn't at all fall afoul of the regulations of the F visa. If you're signing autographs and getting paid per autograph at some kind of an event, that's certainly some kind of work, some kind of services. Much of the value of that, though, doesn't come from the work itself. It comes from the name, image, likeness. But insofar as the work or services go, not employment, not if it's done on a one-off basis. If you are employed at a car dealership 1 day a week to wash cars, but you're paid $50,000 a year to do that, while most people are paid minimum wage, that's the kind of thing that the NCAA was worried about when they said you can't, you've always been able to go to Home Depot or something as a job, but you can't be paid extra because of supposedly your name, image, likeness. So if you do that, that would be bona fide employment. And that would be a problem for international student athletes here under an F visa. But there's plenty of room to compensate student athletes without anything approaching employment. Although the downside is if Homeland Security disagrees and they deport you, you know, I can call them and tell them they're wrong. I'm happy to do that, but I think that's it.
Great. Okay, let's open it up for questions on either of our topics, Title IV, immigration, what is work or not. And so if our audience has questions, otherwise I will. All right. Yes.
That was really great, and I'm all for finding ways to get blood out of the game, so I appreciate that. But to your point, it seems pretty risky in this age when sponsorship is so driven by affiliation. And I have a contract I'm looking at for a client right now where they have like 12 hours of filming time, and so there is work involved. What do you think the likelihood is that these college athletes will take the risk of being deported to a country of school strategy?
So the question for people on Zoom was just to what extent do you think people are going to accept the risk of deportation to test this strategy? I think we've already seen people take the risk. I'm forgetting right now, but I remember reading an article about someone who was on his way out, right? Someone who already had the pro contract, but hadn't yet changed visa status, was still a student, you know, but was on his way and was doing much more worky things. And they just were like, fine, I'm just going to do this. I would think that's actually the most risky time, right? Because then it's like, I don't want to give up I'm set for pro. I can take a wash on the $3,000 that I might get for this little moment right now. For what your person is saying, I think what we are articulating is if you are contracted to do 12 hours of videoing for something, that's different than somebody who is just using footage that they got at a game or a picture taken from somebody or whatever. That's a different problem. And so if you're paying them for their time to show up at the studio and do the recording, that's work. They what?
And it's not just merely me holding a phone to capture the content. If you're a high level athlete, you're having to go into a production studio for the sponsors.
So my answer would be Reed, CCNV versus Reed and its progeny. You know, I think that could be employment, but it might not be. Some of the factors are the regularity of it, the tax treatment of it, the right of the employer or hiring party to control the hired party. Are the tools provided by the hiring party or are they brought by the hired party? So, I mean, you can look at those things. Certainly in Hollywood, a lot of those things, they're generally treated as employment. They're taxed that way. So you hire extras, you typically do that as employment. I don't know that they would have to, but that's kind of how it's evolved in Hollywood. So that might be treated as employment. Yeah.
Yeah, question over there.
Someone spoke earlier about collectives giving a certain amount of money to each athlete, and I think the reality is that we understand that there's going to be some sort of expectation of the athletes, and something that they spoke about with doing charity work of that nature. There's going to be a contract, there's going to be something laid out, and yeah, it's charity work, but if there's a contract, and if there's an expectation of X, Y, and Z, make sure that you maintain your eligibility or whatever, especially if it's going to be treated similarly to what a scholarship is treated like. Is that not an employment contract, especially if they're expected to pay each other? So if do 10 hours of charity sometime during the school year, it needs to be signed off by the head of the handicrafters, whoever. Is that not is there not a concern of reaching that gray area of
Yeah, I don't know why the Matador Club is asking for the charitable work. I don't know where that comes from. I mean, part of that, as I understand, is endorsing the charity. That's easy, because that's not work, but it's certainly not employment.
Yeah, I agree. I think tying things to obligations is the problem. So if instead, I think the Matador Club, from an immigration law standpoint, would be on better footing if they just used the team photo that the studio right? So Texas Tech takes a team photo and they get that photo and they put it on a board and they're like, welcome to Lubbock. That would be name, image, likeness. You're being welcomed to Lubbock by the football team, and that's what they're paid for. And that to me is not work. There's no problem, as opposed to this. It's not even work. Yeah, not employment.
But does the issue come from the idea that the collective is trying to take balance of what they're providing? Is that kind of the problem there?
Yeah, I think maybe, I don't know, why try to, you're just trying to pay them for being on the field, right? I mean, so I think that's and some people probably know this better than me, but I think that's an open question right now as to whether you can pay people for playing if the state law says that you can, because the NCAA guidelines say, well, if there's a state law, go by the state law. If the state law says a collective can pay people for playing, I'm not so sure that that's not okay under what the NCAA said, although the NCAA likes to be cagey and silent, not explain what they're doing. But, you know, that seems like a reasonable interpretation of the language to me, in which case that should be fine.
Yeah, and similarly, again, if you think that, oh, well, no, the collectives are all about the charities, which I don't think they are, but you could do the same thing. Take the team photo and it's like the Texas Tech football team is all about Children's Hospital of Lubbock, right? And then pure NIL, no work, and we don't have a problem.
All right, we probably have time for one more question. If anyone has some burning question about their financial aid or filling out the FAFSA, also. All right, well, we went there and have our panel switch and bring on our next panel, but thank you virtually, Professor Kiska-Schultz and Professor Johnson. Thank you.
So we will be making a change for our last panel. No, please.
And they'll let me see like when PowerPoints go up and something. So they'll be like right there.
I think it's Alfred line and you both have a PowerPoint, right? Yes. Yeah. This is a PowerPoint and Alfred. Yeah. Yeah.
That was awesome. I love it.
Thank you.
Great. Okay. So let's get started with our last panel today. I can talk very loudly. I'm John Lee. I'm a new professor at OU College of Law, and I'm so excited to be here. I asked to moderate our last panel, which is going to delve more into the collectives. I think that we will see some common themes here. So I'm going to keep the intro short so we have lots of time to hear from them and their questions. You can read about their extensive, amazing bios. We will start with Professor Alfred Yen. He is a professor of law at the BC Law School. He's an expert in trademark law, copyright law, sports law, and torts. We will then hear from Professor Alicia Jessup from the Seaver College, Pepperdine University, where she is a writes in sports policy, sports law, sports sponsorship, and sports finance. She has a stellar media career. And then finally, we will hear from Professor John T. Holden. He is an associate professor just down the road at the Spears School of Business at the Oklahoma State University. So Professor Yen.
So thank you for the kind introduction. And I want to also, once again, thank the Law Review, the University of Oklahoma School of Law, Kit and Megan, all of the people who have made our stay here so pleasant, and the hospitality we've been extended has really been a privilege to join you folks. So what am I trying to do here today? What I want to try to give to you is the thought that maybe the NCAA should find a different way of trying to regulate the relationship between this new NIL world and the world of recruiting. Now, where do I come from on this? I think the NCAA has a bit of a history, particularly with recruiting, to writing rules and saying, we will punish you if you break them. And then what we find out is that people pretty much go ahead and do the very thing they were told not to do, and doggone it, nothing ever happens. And I kind of think that that is what is going on here today with NIL. NIL, it's not supposed to be pay for play. And boy, oh boy, especially with respect to these NIL collectives, it's looking darn close to me, right? I'm starting to have these flashbacks to tax law where, is it form or substance that controls? And second, NIL is not supposed to influence recruiting. And if you think NIL is not influencing recruiting, I have a bridge for you to purchase. Now, on top of that, I want to make the case that the result of the NCAA rules, they're what I would call their prohibit and punish regulatory style, is that they create a market for NIL rights that is actually worse for recruits than if they had just simply said, look, folks, just go ahead and do it, will you? Just go ahead, pay them for being on the team, and go ahead, make them formal offers during negotiation. And the reason I think that this is important is because I believe that the NCAA would say to us, look, the reason we have these rules is to protect student athletes from the supposed taboo of open professionalism. Again, like if you don't think there's professionalism in college sports, that's a pretty hard claim to make today. And what I want to do in my analysis here is to show that that the unfairness of the market that the NCAA creates is because they create a market which is effectively asymmetric in the advantages they give to each side. Recruits come in at a disadvantage, they're first-time players, for example, whereas I guarantee you the coaches and the institutions are experienced at what they're doing. But furthermore, that the market deprives recruits of information that they need to avoid rude surprises and hedging of the contingency that these informal commitments on which NCAA recruiting markets rely get broken. And so that effectively what happens is that the consequences of broken promises are worse for recruits than they are for institutions. Okay, so here's a slide of how's recruiting supposed to work. Well, first of all, the athletes, they're all amateurs. They do this just for the fun of it. They will, of course, choose the school they attend for reasons of academics, not athletics. And to keep the world this way, I know some of you are smiling, you were probably recruited before you were juniors. To keep it this way, we have rules, right? No formal commitments till the senior year through the NLI process. No informal offers before the junior year. That's what they're trying to do. And of course, we all know that's not what happens, right? We understand that NCAA institutions find ways to make informal commitments to their recruits very, very early on. And so, right, again, we have this idea. Everything is informal and uncommitted until the senior year when decisions must be made. We're going to enforce these rules with punishment. As I said, right, the real world of NCAA athletics is the NCAA recruitable athlete is undoubtedly an extremely serious athlete with very real professional ambitions. And they often make choices of their school to attend on the basis of the athletic program, not primarily the academics. And we know that scholarship offers are routinely made to people well before the junior year. Now, what does this do to recruits? This puts recruits under pressure. They have to ask themselves, is it a good idea for me as a 15-year-old to make a supposedly firm commitment about where I'm to attend college? Waiting may be maybe if I think it's a good idea for me to wait, because maybe I'm going to get even better at basketball than I am now, and I'll be an even higher profile recruit in 2 years. Waiting may be an unattractive option if you think that there's a race for spots available, right? That schools are busy making commitments to other recruits, so that if you wait till your senior year or late in your junior year to make a commitment, you've got a problem on your hands. Now, again, I understand if you're LeBron James, that's not going to be a problem, but I suspect most athletes have an issue with this. And then, of course, the big one, I'm being told this is an informal offer. Is it going to be there when I'm a senior? Can I rely on what I am being promised today? Now, we understand most of the time people keep these informal commitments, but again, a little time on Google won't take very long. You can find some fairly dramatic stories of folks who get to the senior year and they don't have a place to play. Now, how does this all happen? Because NCAA rules that supposedly permit these practices have loopholes that permit the supposedly prohibited practice. Informal offers can be arranged through conversations with intermediaries. There are specific exemptions for football and basketball involving telephone calls. A member of the athletic staff can take a phone call at any time. So you send a call to an intermediary, says, hey, look, why don't you call Coach whoever? Coach whoever can answer his phone. An informal offer may be extended then. There's also loopholes around the time of unofficial visits. So we could ask, is this fair to recruits? And I think the first look that many people might give here is, well, sure, it's fair. Both sides understand they're making an informal commitment. Nobody loses a doggone thing. Nobody's being treated unfairly. People understand. You might back out. I might back out. But here's where I think the asymmetry of the market starts to get important. The positioning and the consequences are different, right? Recruits, it's their first time. They don't really know what's going on. Institutions understand what's going on. But here's where, once the informal commitment is struck, here's where I think the asymmetry starts to show up. Let's suppose you made an informal commitment with an institution and you have some doubt about whether you're not sure if you can really rely on it. You might then begin to observe the other side to see if they're behaving like they're fully committed. Now let's compare how the world looks to a recruit versus how the world looks for an institution. You're a recruit. I'm not sure if that offer is going to be there. So what I'm going to do is I'm going to go have an unofficial visit to Texas, right? Now, the college athletic world is a small place. And if you're taking unofficial visits, the institution to which you're committed is going to say, my goodness, our recruit is taking an unofficial visit to another school. I guess he's not that committed. Maybe we better start looking for his replacement, right? There's a warning sign, and the institution can hedge against the contingency of a broken commitment. But from the other side, if you're the recruit and you're to observe that the institution is continuing to recruit additional guards for the basketball team, That doesn't tell you anything because institutions recruit multiple players at every position every year. So you don't learn anything. So that you don't really get the signal, maybe you should be ready to hedge. And now let's get out there at the end. Let's suppose that the deal is broken. For the institution, is it that big of a deal? Probably not, because here again, because of the way the market is put together, the institution is busy diversifying risk. If you know you need quarterbacks, you are not going to recruit just one quarterback for your class. You're going to recruit multiple quarterbacks. Chances are somebody else on the team or that you have recruited is ready to step in and take the position. But if you are the player who has lost a commitment, particularly if you lose the commitment late in the recruiting process, what you're going to do, right? The typical story of a recruit who loses a commitment is that if they continue to play the sport in college, they do so at a less high-end program than that to which the commitment was made. And that kind of makes sense. You know, you're going to have to, you've lost your spot in the line. Okay, so what I've done here is give you a sense of how the world looks just with recruiting, with scholarships only, because what happens with NIL is it just piggybacks on this problem and it gets a lot worse. So how's NIL supposed to work? Well, again, it's still an amateur. And basically the idea here is NIL is absent from recruiting. Institutions may not present offers from NIL collectives or any other third parties to recruits to induce them to come to school. After all, they're choosing the school on the basis of the academic program. We have these rules as in the NCAA's guidance letters, which presumably we're going to enforce by punishment. And I think that what happens is stuff just piggybacks on top of the scholarship recruiting process. Every NCAA athlete now understands that you might make money, and it might be a lot of money if you're in football or basketball. It's around 50 grand now for a Division I football player. It's what the Horns with Hearts, for example, offers. You know you're going to make a lot of money. Now, information about this is freely available on the web, right? Media covers it. Collectives will tell you what they want to pay. And frankly, I think coaches are also very busy informing recruits of what's available here. You get the Saban versus Fisher squabble where Saban is complaining, you know, if this isn't the pot calling the kettle black, right? Dadgummit, can you imagine that? The folks over at A&M, they got their recruiting class by offering them NIL deals. Really? I'm shocked. I'm shocked that there's gambling going on in this casino. And then there's this video that was circulated on the internet of the Texas A&M coach with the recruits near him, and he's waving up at the luxury boxes at the Texas A&M stadium saying, I think these were the words, y'all gonna make a lot of money from the people up there if you come play for us. So we already know that this is happening. The pressure is now mounting on recruits. Every concern they have about scholarships remains, but now they have to ask, do I understand what is being offered to me? Do I? I don't know. I mean, this is a deal that would normally be consummated by a multi-page written transaction, you know, with a lawyer representing somebody. Can I rely on the people offering me these commitments? And if I'm disappointed, I'm not going to be able to go elsewhere with my NLI deal because I can't sign any of these NIL deals, there's NLI and NIL deals until after I sign my NLI commitment. Again, the rules have loopholes. And again, my same fairness question, except now it's worse. And the big kicker here now is it's really worse because there's real money at stake. Earlier in the conference, we heard that many NCAA athletes live near the poverty line. If you were being offered $50,000 a year, that's a lot of money to you. That's a big deal. You might need it to support your family. To get to school and find out that support is not there, I don't think that's very fair. So basically, I'm saying, wouldn't it be better to just let the NCAA institutions do what they're already doing? Let them make firm and binding offers to people at any time they want so that recruits can rely, and there will be consequences to broken commitments. If people want informal commitments, they can agree to informally commit, but now they know they have the option. And I think that that would be both fairer and give the NCAA and institutions an opportunity to regulate the practices of what's actually in the deals. So thank you for listening.
You going to the podium? Are you going to the podium though? I'm going to the podium. All right. Not going to be the only one at the table. Right. Thank you. I want to thank the law review and the faculty here at the University of Oklahoma for the wonderful hospitality and organizing an incredible event. I really wanted to love the NCAA. I really wanted to. I started a sports law blog in 2011 called rulingsports.com. And that year, Mark Emmert was hosting a 3-day conference to reform the NCAA. He wanted to streamline the bylaws, which we now heard are 500 pages long. And so I reached out to the communications department at the NCAA and I said, there's so many bad stories about college athletes. Let me tell a good one. Find me a good story and I will tell it on my blog. I really wanted to love the NCAA. We've heard some great things that college sport has done for the individuals in this room. I'm a first-generation college student. My father was an orphaned homeless person who doesn't even have a high school degree or diploma, excuse me. So I understand the power of an education. I also understand the power of a free ride for that education as I'm 38 years old and still paying off student loans. This is a civil rights issue. Let's call it what it is. This is a civil rights issue. We have a multi-$10 billion enterprise that is largely built on the backs of Black people who go unpaid, and it's wrong. And NIL is the first step. It's the first step, it's the first domino, and the domino has fallen, and guess what? The dominoes are going to keep on falling. What I'm supposed to be talking about is the recruiting advantage that NIL presents, but I needed to begin with that because I haven't heard it said today. When Gavin Newsom signed the Fair Pay to Play Act on an episode of LeBron James' The Shop in 2019, fury was unleashed. You had Mark Emmert threatening to never host another championship in the state of California, the biggest state in this nation. You had athletics directors like Gene Smith at Ohio State University threatening to never schedule another game in the state of California. Championships go through Ohio State. That would be very problematic for the member institutions in the state that I call home. But then the recruiting advantage was made aware. And it's been alluded today, but let's call athletics departments what they are. Athletics departments are the marketing arm of a university. But for athletics departments, we don't have schools ranking in the top 50. We do not have an influx of enrollment and out-of-state applications and donors giving without athletics and teams winning and championships being won. So the recruiting advantage was recognized, and states like Florida swiftly responded to the decision by the state of California. And we saw numerous states, tens of states followed course, but for the Supreme Court's 9-0 decision on June 21st, 2021 in the Alston case, we would not be here today having a symposium on NIL. It was that decision that forced the NCAA's hand to relent and acquiesce to the enactment date of Florida's bill on July 1st, 2021. Why? Because they realized, to Professor Edelman's point earlier today, that they weren't going to get antitrust protection from the court, and so that they were going to have to lobby up and spend millions of dollars roaming the halls of Congress seeking an antitrust exemption to continue this cartel-like behavior. We're at the University of Oklahoma. I was born in 1984. My favorite case that I get to teach each semester is the Board of Regents case. Your school created the model that we find ourselves in, where there are billions of dollars flowing through this enterprise. You fought for this model. You fought for individual schools to own their TV rights. And once that right was restored to the individual universities, they exploited the right, as they should, and it changed the entire landscape of college sports. Landscapes change. It's okay for a governing body's mission to change. It's very rare that an organization that begins in 1906 holds the same mission in 2022. I'm a very religious person. We can look at my church. The mission, we still serve like one big mission, but the practices have changed. The NCAA has dug its heels in on a mission that frankly, in large part is illegal, and it hurts certain people who contribute deeply to it. So the rules changed in part because of the Alston case and the body of state law that restored to college athletes their right of publicity. And to really drive this recruiting advantage home, schools have begun different strategies to attract college athletes related to NIL. We've heard deeply about the booster model, but let's talk about what's going on at the University of South Carolina. South Carolina took it one step further and they created Park Avenue. They spent $2.2 million on a 2-year contract with a group of NFL agents to create an in-house agency so that this team, it's 5 people, can go out into the marketplace and secure marketing deals for South Carolina athletes of both genders across all sports. We used to not let the agents in to college sports. The agents were the bad guys. The agents were the people that we wanted to deeply prohibit our college athletes from engaging with. I've written articles about the need for athletics departments to be more amenable to welcoming agents into the college sport ethos. I'm someone who believes that education changes lives, and it's through education that creates opportunity. Historically, I do not support the NCAA's regimented perspective as it relates to agents, where instead of telling college athletes where the pitfalls lie, what an agent should be doing for them, how an agent should be working for them, we have held them away from agents. So historically, this is a move that I would celebrate. There's some massive problems with it though. Massive problem number 1, the university is employing the agent. And so what this does from a university perspective is first, it attaches some massive liability issues for the university, but it leads me to question, who is the fiduciary duty owed to? Is the fiduciary duty owed to the university, or is it owed to the college athlete? If this firm, again called Park Avenue, is holding itself out as the agent to the athlete, but it's not fully seeking opportunities for the athlete. And an example of that might be, let's say the University of South Carolina has a sponsorship with a soda company. Is that agency going to bullishly search the market to find an opportunity for a South Carolina college athlete from a competing soda company? My instinct tells me no. If my instinct is correct, that's a breach. It's a breach of the fiduciary duty. It's a breach of the duty of loyalty and good faith, and we can go down the line from there. So there's some huge implications from a legal perspective to this model. And the question is, well, what do we do then? The model already exists. How do we respond to it? I disagree with one of my very esteemed colleagues who spoke earlier today about the unionization of college athletes. I think the only way out of the situation that we find ourselves in is to recognize the employee status, at least of revenue producing sport college athletes at the highest level. So I'm talking the Power 5 conferences, if we have 5 conferences when this all shakes up, but the individuals at the 64, 65 schools, depending upon how you count it, I think you have to recognize the employee status of them and allow for unionization, because here's where things are going. When I was a kid, my mom read a book to me called Chicken Little. I don't really remember the details. All I recall is that the sky was supposed to be falling. That's what we've heard about NIL. And I've heard some of that rhetoric today of, if we don't do this, this is going to happen. The sky is not going to fall. We know that the sky in college sports is not going to fall because last week viewership of Kansas football, not basketball, now they're performing very well, unfortunate for us tomorrow, was up over 200% year over year. We were told that once college athletes begin being able to be paid, plot twist, they've been paid for a long time. It's just been under the table. We were told that once they were legally paid, the interest in college sport would eradicate. Every week I tweet viewership numbers from Fox Sports and ESPN that prove the fallacy of that argument. There's a case working its way through the Northern District of California in federal court. filed initially by former ASU swimmer Grant House versus NCAA. NIL is going to look like a child's game compared to the outcome that this case is likely going to bring. NIL was a necessary domino that needed to fall in order for those college athletes in the big revenue producing programs at Power 5 institutions to begin taking a percentage of the television revenue that your university so generously helped create. Thank you for inviting me.
Okay, so finally, we will hear from Professor Holton.
First, I want to thank the Law Review for having me down here. I know that the reception isn't always welcoming when Oklahoma State comes down to Norman. So far, so good. I appreciate it. I want to set a bit of the bigger context because Alicia touched on this with the House lawsuit. There's a lot going on outside of just NIL. NIL was a huge step forward in terms of a change to college sports, but it's not the only thing happening. At the moment, we have the Johnson versus NCAA case going on at the moment, which looks at the athletes under the Fair Labor Standards Act. So again, another potential major shift coming. More pressure on the NCAA is coming down the pipe. We also have the NCAA still going to Congress, as Alicia mentioned. The NCAA is lobbying hard for, as they call it, a federal solution to their NIL problem. And so we've all seen sort of the last decade how effective Congress is in moving legislation, and this is certainly not an uncontroversial subject. So I don't think we're likely to see massive changes anytime soon, but these things are happening outside of NIL, shaping college sports come the next 5 years. On top of the House lawsuit, which threatens to bring a monumental change to college sports. So back after California passed the Fair Pay to Play Act, I worked on an article about reforming the NCAA. And prior to writing this article, I had this brilliant idea that I was going to sign the first NIL deal for an academic paper. And so we eventually published that paper in 2021, and I did sign the first Law Review deal for an NIL deal. But that's to say that I'm a big supporter of NIL, but I have a number of concerns too. So back in probably August of 2021, I got a call from a friend who works in compliance, and he said, Are you seeing what Miami's doing? Are you seeing what BYU's doing? They're just paying the players. These collectives, they're calling them. They're just rich guys and they're just paying players. They aren't doing anything. They aren't using their images. They just want to pay the players. I said, well, the University of Miami is no stranger to scandal. I know a decade earlier. Sorry, Alicia used to work at Miami, so a decade earlier, scandal came out involving Nevin Shapiro, a Ponzi schemer in federal prison. And really, at the time, we were looking at his misgivings at Miami as perhaps threatening Miami with the death penalty for the first time since SMU. What ended up happening is there was some misdeeds, perhaps we'll call them, by the NCAA and how they conducted their investigation. And in the end, Miami escaped fairly unscathed. But I think, one of the things that gets lost in this new world of NIL is the idea that collectives are new. Collectives have been around for 100 years. And there has always been payments to college athletes. We just didn't talk about it. And when we did, we said that was bad. So now we've sort of endorsed this idea that payments to college athletes are good and they're from collectives. And I'm fully supportive of the NIL idea of allowing athletes to make money. And I think, there's a lot of good collectives out there. But one of the other things that is sort of getting lost is that collectives aren't a monolith. There's a lot of variation between the collectives out there. So our first year of NIL has really sort of been an education for everyone. If we look at sort of the context for how we got here, we can look back at 2004 with Jeremy Bloom, the Olympic skier who wanted to play football at Colorado, basically had to choose between football and his modeling career and Olympic skiing. And then, even more recently, if you look at the 2016 Olympics, Katie Ledecky, the swimmer, half dozen gold medals, couldn't take any endorsements during prime earning years of the Rio Games because of NCAA rules. She wanted to stay eligible at Stanford. She went on to win several more national championships, but NCAA rules prevented her from taking NIL money at the time. This all began to change when California moved. And after California moved, states across the country moved, really changing the landscape. And then we arrived at June of 2021. And in June of 2021, we had the Alston decision, which came out on the 21st. And everyone kind of sat there knowing that July 1 at 12:01 a.m., a half dozen states were going to allow athletes to monetize their NIL rights. And everyone was waiting to see what the NCAA would do. I know anecdotally, our athletic department wasn't sure on June 29th what the NCAA was going to do. People weren't sure. They weren't sure if they were going to file a lawsuit. They'd threatened to. And then all of a sudden, at about 4 o'clock Central Time, the NCAA releases a press release with a few bullet points on it. And it effectively says, if state law is in place, follow state law. If state law isn't in place, you can monetize your NIL, report it to the school, has to be for fair market value. A few months later, the NCAA issued a question and answer document. Question and answer document, again, didn't provide a lot of guidance. Banned pay for play. You cannot be paid for playing on the field. Said you had to make deals that were fair market value, but it basically reiterated existing NCAA policy. Then comes about a document in May 2022. And it, again, is basically just a reiteration of NCAA policy towards booster activity. Only it allows these collectives to exist, provided that they aren't being used to induce athletes to come to the university. So like I mentioned, sorry, I'm terrible at PowerPoints and I'm terrible at keeping up with my PowerPoint. As I mentioned, collectives aren't new. So the Carnegie Foundation first expressed concern about boosters back in 1929, saying that these extramural relationships were a real concern and that alumni could have a big effect on athletic recruiting. So basically, since that time, the NCAA has been concerned with booster activity, and they define a booster as representatives of the institution's athletic interests, but it incorporates virtually anyone who has given money to an athletic department. So raise your hand if you've ever given money to the athletic department for something other than just tickets. Congratulations, you're all boosters. And guess what? Like a brand, you're a booster for life. You can't shed that. So according to the NCAA, you now need to comply with their rules. You cannot induce a student athlete to go to a school. The only contact that you can have with prospective student athletes are relationships that you already have, and you can notify the school if you happen to see the next hotshot quarterback. But you cannot have any role and saying, hey, the University of Oklahoma is a great place. Or OSU. So I know I'm standing between everyone and lunch, but I want to talk about a few things that are sort of the concerns that have emerged regarding regulating collectives. The NCAA has largely sat on their hands, much like they have with NIL generally. There hasn't been a ton of clear response. It's mainly been, okay, here are some responses that you could have already found yourself. Don't break the rules. Additionally, we've had these cases. We've had the Miamis. We've had BYU. These events where people are questioning, okay, well, we're reading the rules and we aren't sure how this complies with them. NCAA says they're looking into it. We know they sent investigators out to Miami. We know they talked to the big booster there. Nothing comes of it. Nothing comes of it. So a lot of schools are taking a very cautious approach. Much like I think many people are taking a cautious approach with advising international student athletes. The consequences are significant if you're wrong. But what this ends up doing is it ends up penalizing schools that aren't taking risks. Schools that are willing to take the risks are at a huge advantage because they don't care. The NCAA hasn't shown a willingness to enforce the rules regarding collectives, which leaves those schools willing to break the rules at a huge advantage. So in our paper, we sort of lay out 4 possible solutions. So one is to do nothing and just sort of hand over control to the schools, the conferences, and take a step back from regulating NIL activities and basically just say, this is a free market. Sort it out yourselves. We aren't going to play a role in that. If the conferences want to come up with some rules, go ahead. Second option is draw a line in the sand and you say this stops now. We are going to enforce the rules. This is what they are. We are going to establish binding precedent and move forward with that. Challenge with that is Justice Kavanaugh's words that the NCAA is not above the law hang over everyone's head. Everyone is concerned about concerted action by the NCAA attempting to regulate NIL on a mass scale. So another alternative, establish fair market value. Determine what is fair market value or some calculation for determining fair market value. Again, at the national level of the NCAA, you run into serious concerns about offending Justice Kavanaugh's clear words, inviting future challenges to NCAA restrictions. Another alternative, and I don't want to spoil the ending, but I don't have a solution. I'm not sure what the right answer is here. Another solution is simply to have schools bring stuff in-house. Let's bring this under the umbrella of the university. South Carolina's done this. They have not done it how I would do it, but bring it in-house, have that institutional oversight, ensure that the athletes' interests are being protected, and stop allowing or at least provide some oversight to the market that's out there that right now has a number of unscrupulous actors in it. And there's not a lot of guidance for student athletes. So I know we've got a few minutes for questions, but I'll sort of stop there.
Great. So we have time for a few questions. I will actually take the first one, which is, it seems like one of the first issues is sort of how we see the schools vis-a-vis the players, right? In that, on the one hand, we think that they are looking out for the players' best interest, but on the other hand, they have a lot of incentives not to do so. And so I'm curious if there are thoughts about perhaps a school sort of paying for the representation of players, right? That would be outside, right? Which is what we do on the insurance side, right? Where we say, if there's an inherent conflict of interest, we recognize that and we will give these players that ability to get the information, to have the bargaining power.
I'm kind of curious, just as I hear you say that, sorry. I'm kind of curious, I hear you say that. At what stage are you proposing that the institutions would do this? I think it would be potentially, I mean, I think we all say there's a conflict of interest. I think even Insurance Defense Council has conflict of interest issues that I don't see going away in this context. But I could see them being even potentially more multiplied in situations where we're talking about recruits as opposed to existing athletes. And I suspect that for many people, the first encounter they will have with NIL is during the recruiting process. So those are questions I would have. I do not have answers.
I only had 12 minutes, so that's not a lot of time to get into the crux of this. But from an agent perspective, if we truly want to protect college athletes, this is why you need to allow the unionization of at least your high revenue producing athletes, because we need a union to certify the agents. And the only way we're going to remove the conflict of interest from the school is if we take the school out of the representation side of things. One thing that is related to this that I didn't have time to get to is what NIL has really opened up to me is the shortfalling of us as individuals in higher education. Data shows that only 36% of college students graduate with any financial literacy education. And so we're seeing play out these holes that in each panel we have identified. College athletes don't know about this. College athletes don't know about that. Okay, well, what are college athletes? College athletes are college students, and our system of education has largely failed a lot of Americans to deal with adulting and basic principles. And it goes deeper than higher education. I don't want to put the blame fully on us. But this is an opportunity for us in this space. It's an opportunity to reimagine what education looks like in America and to ensure that the rising adults in this country have the tools necessary to survive beyond the fundamentals of whatever major that they've selected.
If you get to where you suggested we sign a contract, you think then it becomes fairly for university to say, but if you transfer, you're going to give up all the parts. Or if you sit out the whole game, you're going to forfeit all the parts.
That's a really interesting question, and I'm not sure I know the answer to that. Here's some of the issues I think about. So first of all, I think that scholarship agreements are generally on a year-to-year basis. Is that correct? Can be 4 years now. So I think that would be, I think there's some interesting questions about the annual renewability of NIL deals and how they might structure that, right? Because if you really wanted to have that, you could say, well, you know, your NIL deal is good for a year and then so on and so forth. I think the second thing that I find complicated is that at least the way the NCAA has set this up now is it's a multi-party transaction, right? If it, at least as I'm suggesting, the university is going to get involved in is just as John suggested, I think some really interesting fiduciary and liability questions come up. Who's on the hook here? If the university is on the hook at all, then we're talking about an arm of the state contracting with a citizen. And I think at that point, we may also get to some interesting questions about what is the constitutional limitation on the kinds of contracts an institution can put in front of a prospective student. And then again, of course, if the idea of collective bargaining comes up in their designated employees, then I think the world changes yet again.
Quick question on the flip side, from looking at the actual product standpoint, not necessarily the actual. Ultimately, if left unchecked, shouldn't this ultimately lead to not necessarily the destruction of the end product, but a dilution of the product where a lot of people don't follow it.
the reason why the NFL has a NBA as a union, I think there's a reason Congress made an exemption for Major League Baseball as far as caps and so forth. To keep the competitive advantage across the board and to keep the interest in the sport. Sorry, are you referring to college sports as the product? So just to repeat the question for Zoom, the question is effectively, is there a risk that this is going to be deleterious to college sports? Is that correct?
So my take is, no, I don't think it will be. I don't think we've seen evidence of that. We've seen a number of academic studies looking at sort of the economic impact, and it's had no effect on the interest in college sports. I know there's football studies. I believe there's basketball studies showing similarly. I think anecdotally, we can see from the television numbers that no one seems to care so far. So does that change if every college athlete is making Dabo Swinney money? I don't know. But my guess is probably not.
I think the solution to the hypothetical you're proposing, and I'm the faculty athletics representative to the NCAA for Pepperdine, and I make a lot of friends in those meetings, as you can imagine. But I'm constantly beating this drum, and so far nobody wants to listen to me. Deeming or recognizing the employee status of the revenue producing sport athletes takes away all of these problems, because what you gain access to is the non-statutory labor exemption. And what that means essentially is you can start placing these restrictions. We have a full free agency model in college sport now because of the transfer portal. If you want to get rid of that full free agency model, you have to negotiate. You need to collectively bargain. And it would solve all of their problems if they would just recognize the employee status. And I don't even think it would be that dire of a financial consequence to the point that people are assuming it would be.
Sorry.
So one more question. Well, thank you so much.
Hello, everyone. My name is Adam Hines. I have the honor of being the editor-in-chief of the Oklahoma Law Review this year. And don't worry, I will be very brief. I know I'm standing between you and lunch, but I have a number of people I have to thank. So first, I want to thank all of the attendees, both in person and on Zoom, for attending this event. The Oklahoma Law Review has been in existence since 1948. This is our 75th year. And in all of those 75 years, we've been providing timely and relevant discussion of legal issues for the public. And I think this event, particularly today, fulfills that mission with NIL. And I'm really proud to sit in the audience here today and listen to our esteemed panelists and faculty and moderators really talk about the practical effects on people's lives and on the actual institutions and the sports that we love, because I know it's that care that we have for those people and these institutions and these sports that makes us all care enough to be here today. So thank you to all the attendees. I also have to thank our wonderful panelists who have really dealt with all the nuances and the complexities and brought to bear all the different perspectives, some of which in conflict with each other, that I really appreciate hearing people go back and forth. That's what the law is all about anyway, a little argument. And I really have to thank our moderators, of course, some of the exceptional faculty here at the OU College of Law, Professor Eric Johnson, Professor Megan Shaner, and Professor John Lee. Can we give them a round of applause? Then I have to give a very special thanks to our faculty sponsors, Professors Megan Shaner and Professor Kit Johnson, who have worked tirelessly with us, with our Symposium editor, and Cape, who came to us with this idea, who have shepherded it all along through the summer and in the last few months. So thank you so much to both of them. Let's give them a round of applause. Then, as I just mentioned, OLR's incredible symposium editor, Miss Ann Cape, has done a phenomenal job at every step of the process. Every time she comes to me with an update, I just wanted to give her a hug for doing such a great job planning everything. So please welcome me in giving a hearty round of applause to Miss Ann Cape. Then I have to thank OLR's wonderful and supportive advisor, Dean Melissa Mortazavi. I don't know if she's here right now. I'm so thankful that she was able to come. She's been a support. She was at the dinner last night. So thank you, Dean Mortazavi. And thank you to Carol Booth. I think she may be across the way getting lunch ready, but she has also done so much work as the Director of Communications, spreading the word about today's event. I'm sure she's the reason that a lot of you heard about it and are here today. So thank you to Carol Booth. Also to Shannon Overstreet at the College of Law and the Financial Services Department, who's done great work coordinating all of the logistics and working with Anne, Professor Johnson, Professor Shaner. And I also have to thank all of the wonderful Oklahoma Law Review members and candidates, both now for showing up today to volunteer and for all your editing work in the future, for the site checks you're doing now. I am so thankful you do it, and you do incredible work, and it makes my job so much easier. So can we please give a round of applause to all the candidates and members? Thank you. My last thank you is, of course, to Dean Kathleen Guzman and the OU College of Law for supporting this idea and supporting us. And with that, I'll release us to lunch with one note. We are going to the south entrance of the College of Law. So we'll head just down the street to the main entrance with the archway that says law above it. You can't miss it. And a fountain full of pumpkins. So let's go have lunch. Thanks, everybody.